The House will come to order. Prayer by the chaplain.
Gracious Lord, we thank and praise you for the beauty and bounty of the creation which surrounds us and which you have given us. Most especially do we thank and praise you for the God-given freedoms we enjoy in this land and for the fact that we have a government dedicated to protecting and preserving them. As this assembly meets, we pray your special blessing on these elected leaders that they might think with clear minds, speak with humility and grace, and act with true godly wisdom. Grant that setting aside personal ambition and moving beyond partisanship, each of these members might endeavor to serve the common good. Remind them that as human beings, we are all created in the image of God and are thus possessing a dignity and creative capacity which should be honored by all, while at the same time acknowledging that we are constrained by the physical and social limits that you have infused into the created order. We pray for each member here in their personal lives, for those struggling or burdened by personal or family matters. We ask you to grant resolution and a return to normality. For those wrestling with spiritual issues, we ask you to grant comfort and relief. Help each to exhibit a true and genuine concern and compassion for the welfare of other members, as we are all children of the same Heavenly Father. Bless our time together. Grant that it may be productive and God-pleasing. In the Lord's name we pray. Amen.
The pastor for today is my friend and former neighbor, Pastor Fred Hinz from the Lutheran Church Missouri Synod in Gaylord, Minnesota. Please remain standing and recite the Pledge of Allegiance to the flag of the United States of America. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Thank you. The clerk will take the roll. Clerk will call the name of the member remoting remotely.
Momani Hildsley.
Momani Hildsley, present.
Momani Hildsley, present.
The clerk will close the roll. A quorum is present.
The clerk will read the journal of the preceding day.
Journal of the House, 94th Session, 2026, 65th Legislative Day, St. Paul, Minnesota, Tuesday, April 28th, 2026.
If there is no objection, further reading of the journal will be dispensed with, and the journal will be approved as corrected by the chief clerk. Hearing no objection, the journal is approved as corrected by the chief clerk. Comparison reports. A copy of this order of business is online. If there is no objection, the motions will prevail. Hearing no objection, the motion prevails and the substitutions will be made. Second reading of Senate files.
Second reading, Senate File number 1714.
Second reading.
Second reading, Senate File number 2814.
Second reading.
Second reading, Senate File number 3210.
Second reading.
And second reading, Senate File number 3432.
Second reading. Introduction of bills. The following House files have been offered for introduction today. The chief clerk will report the House files and give them their first reading.
Introduction of first reading, the House Files 5099 through 5102.
First reading, House files 5099 through 5102. Reports from the Committee on Rules and Legislative Administration.
NISCA from the Committee on Rules and Legislative Administration, pursuant to Rules 1.21 and 3.33, designates the following bills to be placed on the calendar for the day for Monday, May 4th, 2026, and establishes a pre-filing requirement for amendments offered to the following bills. House File numbers 1082, 1141, 1270, 3521, 3522, 3532, 3860, 3679, 3684, 3732, 3900, 3919, 3972, 4006, 4252, 4462, and 4492, and Senate File number 4807. A lot of them.
Calendar for the day. The first bill on the calendar for the day is House File 3426. The chief clerk will report the bill.
House File number 3426, an act relating to natural resources, appropriating money from Environment and Natural Resources Trust Fund.
I recognize the author of the bill, Representative Jordan.
Thank you, Mr. Speaker. Members, this is the annual LCCMR bill that uses funds from the Environment and Natural Resources Trust Fund, which is funded with proceeds from the lottery. This year, the LCCMR bill funds 108 projects totaling $102.036 million, and none of that comes from the general fund. It also funds the newly created Community Grants Program. The LCCMR funds environmental projects in every corner of this state. We fund projects in resiliency, water, outdoor recreation, fish and wildlife, and energy. I want to take a moment to thank all the members of the LCCMR, in particular our citizen members, and I especially want to thank LCCMR Director Rebecca Nash and her entire staff, Aaron Barton, Lisa Biagoette, Mike Campana, Tom Dietrich, Noah Fribley, Diana Griffith, Tiffany Schaufer, Ajiv Shah, and Michael Varian. 82% of Minnesotans voted yes for these programs when it was on the ballot in 2024. Minnesotans love investing in our natural resources, scientific research, and playing outside. I encourage your support and can answer any questions.
There are no amendments at the desk. The Chief Clerk will give the bill its third reading.
Third reading, House File Number 3426.
Third reading. I recognize a member from Ramsey, Representative Fisher.
Thank you, Mr. Speaker. I rise in support of the bill. This is a great bill. I appreciate Representative Jordan bringing this forward. I want to say thank you to Co-Chair Heinzman for the work that we've done. We've got a great integrity piece here. One of the things I do want to raise, and we talked about it a little bit at our last meeting, is we did make one change for a group out there that had misused, made a false claim of support on the LCCMR logo. And one of the things we did, we ended up cutting funding to the group, and I think that might have been a little severe because the primary purpose of the grant was to help educate 12,000 kids and get them exposed to the outdoors, kids that typically aren't out there. So what I would ask as we move into the conference committees, give thought as another appropriate way where we maybe can do some funding to help the kids out there, but also make sure we take the logo very seriously. We want to make sure it's properly used, so there needs to be some kind of penalty. I'd like to see something that's a little bit more appropriate to the violation. Otherwise, I do support a very strong green vote for this and continue conversations. Thank you.
I recognize a member from Crow Wing, Representative Heinzman.
Thank you, Mr. Chair. And I'd like to start by echoing the thanks that Rep. Jordan was expressing for those that have worked hard at the LCCMR to support the process and get us through all of the project presentations and the information that was provided to us as members of the LCCMR. I would like to highlight for members a couple of things that I think shouldn't be novel, but unfortunately are, and I think that we did do some especially good work. Chair Fisher and I and members of the committee making sure that as we stand up a new program here in Minnesota, that we're forward-thinking in our approach to that and making sure that there are not loopholes there or opportunity there for fraudsters. One of the things that we did right out of the gate is we invited in the OLA and we asked the auditor, hey, what are your recommendations based on what the DNR has put forward in terms of a process for the community grants program? What would you suggest that we do statutorily to make sure that integrity is there? And they provided some terrific guidance to us, and we took those recommendations, and we're bringing them forward to you in the LCCMR today for your consideration. And I believe that we're gonna be a model going forward when we do have an idea, hey, we really want to work on one thing or the other. We need to be, again, proactive, and we're doing that today. One of the great things about this new community grant program, and in a bipartisan way, we came to agreement and found an opportunity together to work on something that really shouldn't be ignored in Minnesota, and that's aging infrastructure, specifically trails. And I've used examples all over the state during committee talking about trails that are falling into disrepair. It's always fun. It's very sexy to talk about a new project and a new point or opportunity for families to visit, and mine included. We like getting out there and enjoying all of those things. But sometimes the pavement or the dirt in some cases, and there can be washouts, there can be a lot of maintenance that has been missed. And through this new community grants program, you can apply for a grant up to $2 million to get help to bring that back to its original splendor, if you want to put it that way. Pavement may not be that exciting, but when you're potentially going to be hurt or a kid might fall into a pothole, you really appreciate that a trail has been maintained versus the alternative. So I wanted to highlight that for members and ask for your support today. I think we have a pretty good bill before you. A lot of work has gone into the selection of projects, and I would encourage a green vote.
Any further discussion? I recognize the member from Hennepin, Representative Jordan.
Vote green really fast so we can go play outside.
There being no further discussion, the clerk will take the roll. Members, please vote. The clerk will call the name of the members voting remotely.
Green.
Go ahead. Go ahead, Julie.
Green, aye.
Green votes aye. McDonald. McDonald.
Yes. McDonald, yes.
McDonald votes aye. Momani Hiltsley.
Momani Hiltsley, aye.
Momani Hiltsley votes aye. Perez Vega.
Perez Vega, aye.
Perez Vega votes aye.
The clerk will close the roll. There being 117 yeas and 15 nays, the bill is passed and its title agreed to. The next bill on the calendar for the day is House File 4151. The chief clerk will report the bill.
House File Number 4151, an act relating to occupations, modifying eligibility of certain applicants for license to serve as private detectives or protective agents.
I recognize the author of the bill, Representative Witte.
Thank you, Mr. Speaker. House File 4151 is a private detective board agency bill. It's a bipartisan bill. The bill ends partnership detective licenses. Most private detectives currently work under individual or corporate structure. The bill also makes it clear that the controlling corporate officers and qualified representatives would each have to pass the background check. The bill ensures that disqualified people are not the secret power behind the throne of a licensed security company, and also ensures that a person who has been convicted of disqualifying offenses in another state or under federal law is not improperly issued a license by the state of Minnesota. I appreciate a green vote today. Thank you.
There are no amendments at the desk. The chief clerk will give the bill its third reading.
Third reading, House File Number 4151.
Third reading. I recognize the member from St. Louis, Representative Johnson P.
Thank you, Mr. Speaker. Thank you, Representative Witte, for bringing the bill forward. It's a good bill for an agency to continue doing their work, to be effective and efficient in what they do. Encourage a green vote.
Any further discussion? I recognize the member from Dakota, Representative Witte.
Thank you, Mr. Speaker, and I appreciate a green vote today. Thank you.
Seeing no further discussion, the clerk will take the roll. The chief clerk will call the name of the members voting remotely.
Green.
Green, aye.
Green votes aye. Aye. McDonald.
McDonald, aye.
McDonald votes aye. Momani Hiltsley.
Momani Hiltsley, aye.
Momani Hiltsley votes aye. Perez Vega.
Perez Vega, aye.
Perez Vega votes aye.
The clerk will close the roll. There being 133 yeas and 0 nays, the bill is passed and its title agreed to. The next bill on the calendar for the day is Senate File 4760. The Chief Clerk will report the bill.
Senate File number 4760, an act relating to public safety, the second engrossment.
Before the author explains the bill, we have an amendment at the desk to insert the House language into the Senate file. The Chief Clerk will report the amendment.
He moves to amend Senate File number 4760, the second engrossment. The amendment is coded DEA 3990.
I recognize a member from Sherburne, Representative Novotny.
Thank you, Mr. Speaker. That is my motion, and I recommend a green vote.
Discussion. Seeing none, all those in favor of the amendment, please signify by saying aye. Any opposed, say nay. The motion prevails. The amendment is adopted. I recognize a member from Sherburne, Representative Novotny.
Thank you, Mr. Speaker. House File 3990 is a public safety package. It contains 16 bills that have already been 16 bills. 13 of those bills have already passed off this floor, standalone bills. The bills that the House have passed are part of this bill. 2169 from Representative Schwartz, a bill about allowing protective orders from Canada be recognized under Minnesota's second-degree unintentional murder status. House File 2358, Representative Van Spinbergen's bill on increasing penalties for sextortion cases. House File 3155, Representative Tabsky's bill that adds gift card fraud to organized retail crime statutes. House File 3453, Representative Hansen's bill that increases the age to 21 for the legal possession of kratom. House File 3496, Representative Harder's bill that requires offenders who are able to pay court-ordered restitution to make those efforts before they are released. House File 3768, Representative Curran's bill that makes changes to the Department of Corrections licensing of juvenile detention facilities. House File 3769, also Representative Curran's bill that updates the Department of Corrections substance abuse care and mental health status. House File 3771, Representative Pete Johnson's bill that gives extra 2 weeks to the Department of Public Safety to report the legislation on the Disaster Assistance Contingency Account. House File 3782, Chair Moeller's bill that requires disclosure of chemical irritants discharged in buildings. House File 3825, Representative Rapinski's bill that makes changes to victims' rights requested by the Office of Justice Programs. House File 3826, which is Representative Witte's bill that makes changes to the Department of Public Safety fraud and finance crime sections that the BCA requested. House File 3827, Representative Duran's bill that makes technical changes to the BCA statutes. House File 4151, Representative Witte's public or private detective board that we will pass in a little bit. In addition, or I guess we just passed it. In addition, there have been 3 other provisions that have not been heard on the floor yet. Mr. Speaker, I'd like to yield the floor to Representative Curran, who will talk about House File 3870, a bill that updates the Department of Public Safety data and terminology.
I recognize the member from Ramsey, Representative Curran.
Thank you, Speaker. Thank you so much, Chair Novotny. Yes, House File 3870 was heard in the Judiciary Committee. Thank you so much for that, Chair Scott, for giving us time to go through that and work together on it. I really appreciate that. House File 3870 comes from the Department of Public Safety for the Office of Justice Programs. When OJP collects, analyzes, and distributes crime and justice-related data, currently they are not, they don't fall under a classification process. So what this bill does, or what this provision of the package would do, is protects that research data on individuals. It also clarifies that data collected from families and victims through the work of the Missing and Murdered Black and Women and Girls Office and the Missing and Murdered Indigenous Relatives Office, that any research that they collect, that data would also be private. Finally, this section removes outdated language in statute that relates to victim survivors of abuse. And again, thank you, Chair Scott and Liebling, for giving time in Judiciary, and I appreciate Chairs Novotny and Moeller for carrying this in the bill today. Thank you.
Recognize the member from Sherburne, Representative Novotny.
Thank you, Mr. Speaker. The underlying bill of this package is my bill 3990. A recent Court of Appeals decision interpreted the Criminal Offender Rehabilitation Act to mean that if a job applicant can produce certain documents outlined in this statute, has sufficient rehabilitation that is established, and that the public employer does not have any discretion to disqualify an applicant whose conviction directly relates to that position. In this case, an applicant was disqualified from Minute for an IT position within the Department of Education after a criminal background check showed a conviction for the possession of child pornography. The Court of Appeals held that once the applicant provides the documentation listed in statute, the applicant has satisfied the statutorily defined means of demonstrating rehabilitation and cannot be qualified from employment. House File 3990 would restore the balance between the second chances and allowing public employers the discretion to make hiring decisions based on specific duties, responsibilities, and the applicant's fitness to perform those duties of that position. Madam Speaker, I would also like now to yield the floor to Chair Moeller, Mr. Speaker. Would like to yield the floor to Chair Moeller to talk about her House File 3946, a bill that modifies domestic abuse cases and reporting, and would make any other opening remarks she would like to make.
Recognize the member from Ramsey, Representative Moeller.
Thank you, Mr. Speaker, and thank you, Chair Novotny, for your work on this bill, and to the committee. I am really proud of the bill that we put together, and also that many of you have seen so many of these provisions as they have passed off the floor as standalone bills. I did want to spend a minute, as Chair Novotny mentioned, to talk about House File 3946, which is a part of this, and this is a domestic violence bill that I worked on over the interim. I had the opportunity to meet Jana Williams, whose niece Allison was murdered in Minneapolis, and she was a victim of domestic assault. The case was handled horribly. There are still audits and ongoing investigation in that case, but talking to her and reading so many stories lately of women, mostly, who have been killed, or bystanders who have been killed in the course of domestic abuse, really had me take a hard look at some of the statutes, meet with a lot of different stakeholders, and figure out how can we make a difference this session. And I do want to thank Chair Rarick and Chair Scott for your collaboration on these issues over the years as well. We've done some really important work in the past and even this year on some other bills. So what this bill does, members, it includes some reporting provisions right now for officers who are right now for law enforcement investigations involving use of force. We want to know which of those resulted as a result of domestic violence. They started out as domestic violence cases. We also want to get some more data on domestic violence cases and how those are being reported, how they're being responded to, who are the parties involved. We just really don't collect good data on that right now. And one of the most important pieces of this is changing the gone on arrival situation. So right now in misdemeanor cases, arrests can only be made within 72 hours. And what I've heard from victims and those who work a lot on these cases is that it's all too easy for an offender to be able to hide out for those 72 hours, and then nothing ever happens to that case, and then the offender comes back. And so we have put a time frame on that. It's 28 days in this bill. I think in negotiations it's going to end up being 14 days, but at least that gives more time to effectuate that arrest. And then we also have some provisions in here for when somebody is arrested and taken to the jail, what factors should be considered before that person is just released before seeing a judge, or even when they are in front of a judge, what are some additional factors in these domestic violence cases that can be considered? There was a recent homicide where the judge apparently did not read the order for protection that the victim wrote about the increasing threats to her life. And so we think it's important that either law enforcement, judges, whoever's making these decisions, have the full picture in front of them so that they can make sure that victims are kept safe. Thank you, Mr. Chair.
There are amendments at the desk. The chief clerk will report the amendment.
Novotny moves to amend Senate File Number 4760, the second engrossment, as amended. The amendment is coded A5.
I recognize the member from Sherburne, Representative Novotny.
Thank you, Mr. Speaker. The amendment is, simply inserts the House language into the bill that came from the Senate.
Any further discussion?
Mr. Speaker, I'd like to say that A5 changes the effective date for the reasonable discretion for public employers to do their enactment. That is a request that came from MMB as related to this, and the sooner we can get this enacted into a law, there might be a court case dismissed. So I recommend a green vote.
I recognize the member from Ramsey, Representative Moeller.
Thank you, Mr. Speaker. I recommend a green vote as well.
Any further discussion to the amendment? All those in favor, please signify by saying aye. Any opposed, say nay. The motion prevails. The amendment is adopted. There are amendments at the desk. The chief clerk will report the amendment.
Lee F. moves to amend Senate File Number 4760, the second engrossment, as amended. The amendment is coded A7.
I recognize the member from Hennepin, Representative Lee F.
Thank you, Mr. Speaker, and thank you, Chair Novotny and Chair Moeller, for your staff in helping me prepare the A7 amendment. So the A7 amendment is from House File 4371. I carry on behalf of the Office of the Legislative Auditor. This is just to allow for the OLA to request the BCA to conduct fingerprints for them, and when they request information regarding federal tax information, this requirement is a new rule that's required from the federal government. And so I hope you support this amendment. Thank you.
I recognize the member from Sherburne, Representative Novotny.
Thank you, Mr. Speaker, and thank you, Representative Lee, for bringing this forward. This is an important bill. It helps the OLA get their work done and is in compliance with federal law. I recommend a green.
Any further discussion to the amendment? Seeing none, all those in favor of the amendment, please signify by saying aye. Any opposed, say nay. The motion prevails. The amendment is adopted. There are amendments at the desk. The chief clerk will report the amendment.
Witte moves to amend Senate File Number 4760, the second engrossment, as amended. The amendment is coded A8.
I recognize the member from Dakota, Representative Witte.
Thank you, Mr. Speaker. First, I want to start off by saying thank you to Representative Jessica Hansen for bringing this bill last year and in looking after our persons that are detained in jail and providing medications. After significant collaboration with community stakeholders, the Minnesota Sheriff's Association and Department of Corrections have found clarifying language to hopefully strengthen this bill. The amendment meets the operational realities of jail facilities while ensuring essential medical safeguards for those in custody. It is important to note the partnership between the sheriffs, community stakeholders, and the Department of Corrections on this amendment. It clarifies implementation, ensures safe medical services that protect the lives of our incarcerated individuals. I ask for your support. Thank you.
I recognize the member from Dakota, Representative Hansen J.
Thank you, Speaker, and thank you, Representative Witte, for working on this, and especially thank you to Chair Moeller for really leading the charge on making sure we get this right this year. This was worked on between the Sheriff's Association and the advocates, and they have agreed on this. I had worked really hard on this last year, and my support this year was contingent on getting the support of all of the folks who joined me last year, including the families of folks who have unfortunately lost their lives or become permanently disabled without this law in place. So I just want to encourage a green vote today, and thank you again to Chair Moeller for really pushing this forward. Thank you.
Any further discussion to the amendment? All those in, I recognize a member from Ramsey, Representative Moeller.
Thank you, Mr. Chair, and I want to thank Representative Witte for carrying this. I just want to say when members voted for this bill last year, it had overwhelming support, and unbeknownst to us, we were met with a lot of opposition after the fact, and instead of coming to us for a solution, unfortunately, one of the private companies started a lawsuit that the sheriffs joined onto, which was really rather unfortunate. And in fact, I think it made things delay even farther for getting changed. So in spite of all of that, I'm really glad all the stakeholders were able to work this out. And as often happens here, we often have bills that we pass that we need to make some changes on in the next year. It doesn't mean we think we did anything wrong the first time we passed it, but we needed that clarity. And so again, recommend a yes vote. Thanks.
Any further discussion of the amendment? Seeing none, all those in favor of the amendment, please signify by saying aye. Any opposed, say nay. The motion prevails. The amendment is adopted. There's an amendment at the desk. The chief clerk will report the amendment.
Durant moves to amend Senate File Number 4760, the second Grossman as amended. The amendment is coded A3.
I recognize a member from Beltrami, Representative Duran.
Thank you, Mr. Speaker. This is a pretty simple amendment here. It actually keeps the age of delinquency at the way it is right now. This was brought to me by some of the stakeholders involved, and by now you guys should have gotten and received multiple packets on your desk. And the first page, you're actually going to looking at the Minnesota Juvenile Justice Advisory Committee. So they're the ones that we actually formed to actually create a format for us to follow in regards to this type of behavior. They are actually wanting this amendment to go today. So, and multiple other people inside here, just to go along with the Minnesota Association of Minnesota Counties, Minnesota County Attorneys Association, Minnesota Association of County Social Services, Minnesota Inter-County Association, Minnesota Associations of Community Corrections Administrators, Minnesota Corrections Associations, and so on. We have in here MPPOA, LELS, Sheriff's Office, Chiefs of Police, and we also have a letter from the American Indian Child Welfare Advisory Council, all in support of this amendment. It's pretty simple, guys. We are going to listen. I am listening to the stakeholders here, to the people who actually deal with this on a day-to-day basis, and we think that we are not ready right now for this to go into place. We do not, as the state of Minnesota, have the infrastructure to handle this. It does not mean that we're opposed to this. We just don't have the infrastructure right now to support this change. This is something that we need to slow down. Let's make a good, conscious effort in creating a foundation that we can be successful in this area. At that, I will ask for your support.
I recognize a member from Ramsey, Representative Feist.
Thank you, Mr. Speaker, and I would like a roll call, please.
Seeing 15 hands, there will be a roll call. Representative Feist.
Thank you so much. I rise to encourage members to vote no on this amendment. You have received a letter from a large number of stakeholders as well opposing this amendment, including the Legal Rights Center, the American Civil Liberties Union of Minnesota, Legal Aid, as well as NAMI Minnesota and many other organizations. In 2024, we passed legislation to raise the age of delinquency effective this year because of significant challenges at the intersection of child welfare and juvenile justice. Specifically, because children ages 10, 11, and 12 are not competent to stand trial, they can't receive court-ordered interventions through the delinquency system. Further, interventions available through CHIPS are delayed many months due to competency hearings. As a result, critical time that could have been spent providing services and interventions is instead spent by a court weighing whether these children can understand complicated concepts like constitutional rights, plea bargains, and burden of proof. In nearly all cases, these children are found unable to understand these concepts and make informed decisions about their cases, and therefore, they can't receive court-ordered interventions through the delinquency system, and they cannot be held in juvenile detention facilities. For this reason, we need to make this important transition as planned in 2024 so that we can more promptly and effectively intervene when 10, 11, and 12-year-olds cause harm and require urgent interventions. For these reasons, please vote no.
I recognize a member from Clay, Representative Keeler.
Thank you. I want to tell a little bit more of this story. I sit on Human Services, and I know that there's always like a Department of Corrections or public safety conversation about this. One of the things we've been working on in Clay County for a very long time is a psychiatric residential treatment facility. And I just want to talk about why that is so important in this conversation, because we know at any point in time, if you've been connected to any juvenile detention centers, you can ask. I've asked my county multiple times, and at any point in time, we're anywhere from 40 to 60% of the children who are in the juvenile detention centers actually need high-level mental health supports. We have 30 counties in the West that have signed on to creating a PRTF. And so I think rather than changing things, we need to invest in the things that we actually need to invest in. Human Services talks a lot about wraparound service supports for our kids. And what we know is that when we don't invest in those high-level mental health needs, we're not talking like daily therapy. We're talking actually living in a facility, getting the ongoing supports that you need. And what we hear from adults is that often the kids who have behavior outbursts really need mental health supports. I also want to highlight just the entanglement of the juvenile detention centers and how that impacts us as adults. Right now we know that there's some areas in the parole board that actually, when it looks at sentencing, we look at the juvenile record, which I don't believe is fair. And I think there's a lot of data that the Department of Corrections will provide us to show the direct linkage to when we over-incarcerate young kids, there is an impact in the adults that we have in Minnesota. And so I would just continue to support a no vote on this and do the work that we need around wraparound services, holistic supports for our children. We'll be done.
I recognize a member from Candy, Ohio, Representative Baker.
And thank you, Mr. Speaker and members. I rise to support the Duran amendment today. Our counties need more tools for these young children that have created some real challenges with harm. We need to give them more tools in their toolbox to make sure they put them in a place where they can be more safe. We have better places to house them. Again, I appreciate this amendment. I do not sit on this committee, this public safety, but this is critical that our hearing from our county justice folks. So please, I urge you today to support the A3 amendment today for Representative Duran. This is important. Our counties are asking for it. This is where we've got to give them some more support until we get all of the services in place. Thank you, Mr. Speaker.
Any further discussion of the amendment? I recognize the member from Washington, Representative Johnson W.
Thank you, Mr. Speaker. Just wanted to bring up a letter that I received from the Washington County attorney regarding this. And he says, before these provisions take effect on August 1st, Minnesota must address critical gaps in companion statutes, including child maltreatment reporting and response framework under Minnesota Statute Chapter 260E, and must create clear, workable alternatives that give law enforcement, social workers, schools, and county attorneys meaningful options when responding to offending dangerous behavior by children under 13. They are not saying change it. They are saying they need more time. The people who are going to be implementing this and taking care of this with the children are not ready. It's just not ready yet, and there needs to be more time. So please vote yes on this amendment. It's going to benefit everybody. Thank you.
Any further discussion to the amendment? I recognize the author of the amendment, the member from Beltrami, Representative Duran.
Thank you, Mr. Speaker. I understand the hesitation in the change of this law. But when you have this many people, the people that are dealing with this every single day, coming to us, begging us to not do this because it is going to put them in a hard place, I think we need to slow down a little bit. We say listen to the experts. Listen to the people. We are not doing that right now. We need to understand that the people that are sitting here asking for us to make a change in this law not to completely repeal it, but give some time in order for them to make the foundation to be successful in the change that we are trying to implement. There has been efforts by these people to work with people in the legislation for a delay because we're not ready right now in the state of Minnesota. But it has fallen on deaf ears. What are we telling the agencies? JJAC. What are we telling JJAC? We set up this as a legislation, and we are completely ignoring them. What are we telling our tribal partners? They're asking us to support them right now. We'll ignore it. We won't listen to it. But I'm fine going back to my community and saying that I tried. The thing is that we are failing every single person that's getting in these lists right now, that is in this list. Every single agency is going to be hurt by the actions that we don't take today. And we're okay with that? Are we supposed to support our law enforcement, social services, county attorneys? Are we the body that turn our backs on those groups? What are we doing here, guys? The problem is that you can ignore me now, but you cannot ignore the constituents that are going to be knocking on your doors here pretty soon, wondering, what did we do? This is going to have a drastic impact on the state of Minnesota. You guys already have the list of the people. I'm just concerned right now that we're going to have a 12-year-old person, a kid, a child, stab somebody, rob somebody, and we're not going to have a place to put that person because it's no longer a criminal offense. If you don't trust me, get on your little phone right now and call your attorneys and ask. You can put them on a CHIPS hold, but guess where they're going? To one of the maybe 5 non-secure facilities that we have. Otherwise, they're going back home. Or you're going to stick one of those violent offenders with someone who's actually trying to get help in some of these areas. A vulnerable child at this point in time, you want to put a more aggressive child in with them? Are we setting them up for success? I'm a little concerned right now that we hear all the time that we're here for Minnesota, but we're turning our backs on our juveniles.
Seeing no further discussion, the clerk will take the roll. Members, please vote. The chief clerk will call the names of the members voting remotely.
Green.
Green, no.
Green votes no. McDonald.
McDonald, yes. Aye.
McDonald votes aye. Momani Hiltzley.
Call the names of the members.
Momani Hiltzley, no.
Momani Hiltzley votes no. Perez Vega.
Perez Vega, no.
Perez Vega votes no.
The clerk will close the roll. There being 66 yeas and 67 nays, the motion does not pass. The amendment is not adopted. There's an amendment at the desk. The chief clerk will report the amendment.
Duran moves to amend Senate File Number 4760, the second engrossment. As amended, the amendment is coded A2.
I recognize the author of the amendment, the member from Beltrami, Representative Duran.
Thank you, Mr. Speaker. Well, since that one failed, I'm assuming we're going to go down the same track here. So this amendment is a carve-out for actually crimes of violence for this age group. If we don't want to push it out farther, then let's actually specifically narrow it to particular crimes of violence that we can actually charge these kids and hold them accountable. And I request a roll call.
Seeing 15 hands, there will be a roll call. Any further discussion? I recognize the member from Ramsey, Representative Feist.
Thank you, Mr. Speaker. I rise again to encourage members to vote no. As I said before, there are significant issues with our juvenile justice and child welfare systems. This amendment not only does not address them, it exacerbates them. And I do want to respond a bit to Representative Duran regarding the stakeholder engagement. Stakeholders were fully engaged in 2021 when we first passed this bill off the House floor with no delay. Because none was requested. Again, stakeholders were fully engaged in 2024, where at the request of author Representative Pinto, a delay was put in place. But that was not something that stakeholders requested at the time. There have been numerous meetings over the past year. No one has been completely ignored, and I think it's just important to set that record straight. This is an important issue, and we all take it very seriously. This provision would undermine public safety. Everyone can agree that children who pose a serious risk to themselves or others need intervention, but this can't happen through the delinquency system. Under constitutional due process rights, any person charged has to be competent to stand trial, and if they are not, the criminal charges can't go forward. This does not change based on the level of the charge or the type of behavior. If the court-ordered interventions are necessary for this age group, it has to be through CHIPS. Trying to keep this group in delinquency court will only delay the ability to put intervention in place in the scenarios where timely intervention is most critical. For these reasons, I urge members to vote no on this amendment that would backtrack on our commitment to refrain from criminalizing elementary school children. Thank you.
Further discussion to the amendment. I recognize the author of the amendment, the member from Beltrami, Representative Duran. I recognize the member from Ramsey, Representative Moeller.
Thank you, Mr. Speaker. And I found it interesting, too, with some of the comments on the last one about listen to the experts. Well, we do have experts in the letter that Representative Feist shared with the committee. We have those experts and those stakeholders. You also mentioned, are we the body to turn our backs on law enforcement and listen to the stakeholders who deal with this on a daily basis. I do hope when we discuss the extreme risk protection orders, you'll take a look at the letter from the chiefs of police. But that being said, I just want to emphasize again that we do have expert stakeholders. There has been time to get these systems in place. And neither of the amendments that we're discussing today have been vetted in committee. And again, recommend a no vote. Thanks.
Any further discussion? I'll scan the room like I do. Seeing none, I recognize the author of the amendment, the member from Beltrami, Representative Duran.
Thank you, Mr. Speaker. And there was concerns with this, even by the bill author, has actually acknowledged the fact that there was concerns with this. That's why there was an extension. But the problem was is that there was no real centralized location to be able to feed these places the concerns. So when this bill was actually implemented, the DCYF that you guys created at the same time, the one that was supposed to be the centralized hub for this type of information, didn't get started until June of 2025. Then there was some turnover inside the state. So we're not talking about 2 years to be able to work and try to figure this out because there was no infrastructure set up to get this information to the stakeholders. We completely just bulldozed this through without allowing the infrastructure to actually get in place to work this out. So there was technically 3 or 6 months for us to be able to try to gather as much information as possible to help with this. So it wasn't a long time for us to be able to figure this out. It was a short amount of time, and they're coming to the table now that everything is set in place to ask us for a simple change to help them out a little bit. But it doesn't look like we have the appetite for that. Thank you.
There being no further discussion, the clerk will take the roll. Members, please vote. The clerk will call the names of the members voting remotely.
Green.
Go ahead.
What's the vote? Oh.
Yes.
Green, no.
Green votes no. McDonald.
McDonald, yes.
McDonald votes aye. Momani Hildsley.
Momani Hildsley, no.
Momani Hildsley votes no. Perez Vega.
Perez Vega, no.
Perez Vega votes no.
The clerk will close the roll. There being 67 yeas and 67 nays, the motion does not prevail. The amendment is not adopted. There's an amendment at the desk. The chief clerk will report the amendment.
Greenman moves to amend Senate File number 4760, the second engrossment as amended. The amendment is coded A12.
I recognize the member from Hennepin, Representative Greenman.
Thank you, Mr. Speaker, and that is my motion. This bill, this language bans the hosting, operating, and advertising on prediction markets. This is a really good bipartisan bill that passed out of public safety, was heard in commerce with bipartisan support, and just passed off the Senate floor this morning with 56 votes in favor and only 10 against. It's a really important policy that includes protecting our young people, our communities, and our public decision-making from the shadowy gambling markets that we've seen explode in recent months. And it's critical we act this year. As we have seen this explosion just in under a year, you can now bet on almost anything. And all of the regulations and safeguards that Minnesota and states around the country have been putting in for years don't apply. This bill uses long recognized authority of state and tribal and local leaders to regulate gambling in our state. It prohibits unregulated, shadowy prediction markets and preserves our carefully crafted rules and safeguards around what gambling is, and it governs legal gambling at racetracks, at casinos, and charities. All of that is preserved. What this does is deal with these shadowy prediction markets. But for folks who weren't in commerce, or for folks who weren't in public safety, or maybe haven't been paying a lot of attention on the internet, let me tell you what these prediction markets are. They are gambling platforms that circumvent state regulations and allow people to bet on the outcomes of future events. They're markets operated by companies like Kalshi, Fanatics, Crypto.com, FanDuel, all operating in Minnesota right now, setting up binary contracts that people can bet and get paid based on the outcome of that bet. They allow users to anonymously bet on events and almost anything. This morning I checked Kalshi. You could bet on will FISA be reauthorized? Will Ghislaine Maxwell be released from government custody? Will Airbnb say home sharing during their next earnings calls? Or literally any sports event. And that's thousands of more things. Kalshi in Arabic literally means anything. You can bet on anything and everything. Those platforms make money by charging bettors for bringing users together, and most of these platforms also operate clearinghouses to settle the bets and participate in betting with their so-called trading arms. As I said, this has amounted to an explosion of gambling in the last year, with the safeguards that we have, age verification and others, currently not in place. In Minnesota and states around the country, we have worked hard over decades to have a regulated gambling infrastructure with effective and transparent systems to license and regulate gambling. And since I have been in the legislature, there has been a robust conversation about whether or not we should allow consumer, I thought I heard some prediction markets over here, heading out the door, as we should do with this bill. We have been allowing, we have provisions in statute that have consumer protections, that require age verification, that protect minors, and have money laundering provisions. None of those apply right now. And that's why advocates and members across the political spectrum and across the spectrum of the issue of sports betting in Minnesota support this bill. Minnesota Family Council and MIGA, the Vacating Sioux community, and the Minnesota Catholic Conference, the Joint Religious Legislative Coalition, and others. Because I think we all agree that whether or not you are for expanding regulating or not, or expanding gambling or not, Minnesota should make that decision, and we should decide how it happens here, like we have since the founding of our states. Without these protections, there's no 21-year-old age restriction, no money laundering protections, and no effort to deal with problem gambling. And as the Wall Street Journal reported, it's leading to a disturbing trend of teenage gambling. Gambling experts are actually quite concerned about particularly these prediction markets pulling in young gamblers and targeting teenagers. In addition to skirting our laws, these gambling markets are rife with shadowy self-dealing that threatens to corrupt sports, politics, and policymaking. You probably all heard that at the waning days of the Biden administration, there's currently officials who are betting on pardons. There was a special ops officer who just was caught betting on the Maduro raid. We are seeing reports like this every day. And this threatens to undermine the trust that people have in us, in our system, and in our decision making. So when we talk about what we can do here, this is a simple bill. It is a bill that defines prediction markets as a system that allows consumers to place wagers on future outcomes of a specified event that is not determined or affected by the performance of the parties or the contracts. And then it includes a list: sports, games and dice, war, natural emergencies, elections, legal actions, popular culture, death, assassinations, and the weather. It makes it a felony to create, host, and operate a prediction market, or to sell or advertise or market prediction markets. It focuses on the people providing these, and it requires it to be intentional. So it does not focus on the people participating, it focuses on the market. It creates safeguards, and it includes an exemption to preserve the current framework for legal gambling and the other kinds of future contracts that are currently regulated in Minnesota. And this isn't an abstract issue. We saw last week that a member of the Minnesota legislature was betting on their own election. This came right to Minnesota last week. It is time we act. This is a good bill with bipartisan support. It passed the Senate, and members, I think that this is the moment to do it. And with that, I'd rest the roll call.
Point of order, Mr. Speaker.
Roll call will be provided. State your point of order.
Under Rule 4.03, an amendment may not increase the cost above the limit set in our budget resolution. This amendment creates a felony and has been ruled on many times before on this House floor on public safety bills, is creating a felony does indeed have a cost. So this will add a cost. It is not a no-cost amendment, and I would ask that this point of order be well taken.
Advice. I recognize a member from Hennepin, Representative Greenman.
Thank you, Mr. Chair. It is my understanding there's no fiscal note or there's no fiscal cost, and it just passed off the Senate floor.
Further advice, I recognize the member from Anoka, Representative Niska.
Thank you, Mr. Speaker. I think Representative Greenman is referring to a fiscal note that has been issued on this. The problem with the fiscal note, in addition to it being questionable for the reasons Representative West has noted, this creates a felony. Someone's going to have to enforce the felony. The fiscal note basically just says everybody's going to absorb it. That's pretty questionable. But there's an even more glaring deficiency in the fiscal note, which is that it has absolutely nothing about the lawsuit that the state of Minnesota would face. Representative Greenman referenced a whole bunch of companies that are engaged in this. It's very likely they will all sue the state of Minnesota. But what is absolutely guaranteed and what is not mentioned whatsoever in the fiscal note, both in the Senate fiscal note or in the House fiscal note, is the fact that the U.S. Commodity Future Trading Commission believes that they have exclusive jurisdiction over the types of option contracts that are being regulated by this bill. Not only do they believe that they have the absolute jurisdiction over it, they have been suing states. They sued 5 states in the month of April that is not referenced in the fiscal note. They sued the state of Arizona. They sued the state of Connecticut. They sued the state of Illinois. They sued the state of New York. And they sued the state of Wisconsin, all in the state of April, all in the month of April. So if we pass this, we are guaranteed buying at least one lawsuit, probably multiple lawsuits that the state of Minnesota will have to defend. This clearly creates a cost upon the state of Minnesota beyond that laid out in the budget resolution, and it will, for that reason, Mr. Speaker, I urge you to find the point of order to be well taken.
I recognize the member from Ramsey, Representative Moeller.
Thank you, Mr. Speaker. Well, I will encourage you to find the point of order not well taken. I've got the fiscal note up right in front of me. It does have 0 cost. Something that Leader Niska just said was that it creates a felony, so it automatically creates a cost. That is not true. Lower level felonies, if it doesn't say it's lower level felony, often doesn't have a cost to the Department of Corrections because those are typically probationary sentences. And also there are cases where those costs are absorbed if they're very low level. And so I think it sets a very bad precedent in this body if we are going to say that this is out of order because it has a cost when the fiscal note tells us there is no cost. Thank you, Mr. Speaker.
I recognize the member from Hennepin, Representative Long.
Thank you, Mr. Speaker. I also ask that you find the point of order not well taken. We have never applied a standard that somebody who might sue us in the future leads to a fiscal impact for us. If that was the standard, how could we pass anything? There is the possibility for a lawsuit on any bill that we pass at any time. That is not something that is examined in fiscal notes. It is not relevant to fiscal notes, and it is not relevant to a 4.03 decision on the floor. And as was pointed out, what is relevant is the actual cost that has been examined here, and that cost is 0. There is a $0 fiscal note. So how you can find that this has a fiscal impact when we have a fiscal note that says $0 is beyond me. So, Mr. Speaker, I hope that you find the point of order not well taken.
Further advice. Representative Niska.
Thank you, Mr. Speaker. We frequently recognize especially likely lawsuits in fiscal notes, fiscal impact. The state attorney general's office or somebody is going to have to defend the lawsuit that's coming. Again, the fiscal note has been referenced, but the fiscal note, every single piece of the fiscal note was completed before the month of April. In the month of April, the U.S. federal government has sued several states over similar laws. They certainly will sue the state of Minnesota over this law. The fiscal note is simply out of date, and the point of order is well taken.
Further advice, I recognize the member from Morrison, Representative Schultz.
Thank you, Mr. Speaker. To this point, I agree with Representative West. I believe that you should find this point of order well taken. And I'll just say, Mr. Speaker, to this point that's been raised by Democratic colleagues today, Mr. Speaker, they are mentioning a bill with a fiscal note that frankly doesn't even match the amendment before us. It cites another section of law in the bill that there is a fiscal note for, so it's not a good match. I listened to members in committee all session long talk about fiscal notes not being the correct match, and Mr. Speaker, it's quite clear that their fiscal note that they continue to reference as their reason for you to rule on this point of order, frankly, they are out of order.
Members, I've studied the amendment. I have reviewed the bill. I've considered all of your advice, and I am ruling that the point of order is not well taken. Further discussion to the Greenman amendment. Seeing none, the clerk will take the roll. Members, please vote. The clerk will call the names of the members voting remotely.
Green.
Green votes yes.
Green votes aye. McDonald.
McDonald, no.
McDonald votes no. Momani Hiltsley.
Momani Hiltsley, aye.
Momani Hiltsley votes aye. Perez Vega.
Go ahead.
Perez Vega, yes.
Perez Vega votes aye.
The clerk will close the roll. There being 72 yeas and 59 nays, the motion prevails. The amendment is adopted. There are amendments at the desk. The chief clerk will report the amendment.
Frazier moves to amend Senate File Number 4760. The second engrossment as amended. The amendment is coded A9.
I recognize the member from Hennepin, Representative Frazier.
Thank you, Mr. Chair. This amendment would essentially add the modifications that we have done for updates to our extreme risk protection order. Members, as a body, we should be proud of what we did when we passed the extreme risk protection order. I do understand that we passed this and not everyone voted for this law, but what I can tell you is that it has had a positive impact around the state. It has saved lives around the state. The extreme risk protection order allows for when an individual is deemed a threat to themselves or others, and they have access to firearms, it allows for someone to file a petition to remove that firearm from the individual. There's extreme due process within this. It goes directly to the courts. The courts makes that determination. The individual will have the ability to appeal that, but once the court makes that determination, then a petition is executed, and law enforcement will then go and remove those firearms, or the individual can submit the firearms themselves over to their local law enforcement or to an arms dealer. This amendment, which passed through 2 committees unanimously, bipartisan in a bipartisan way, would just update some issues within the statute based on practitioners. It updates situations such as allowing for an individual to petition directly for themselves to have an extreme risk protection order, because we learned that there were individuals that wanted to do that. It clarifies that anyone from a police department can make a petition themselves and not just the chief law enforcement officer. It also clarifies that in county attorney offices, anyone from those offices can make those petitions. Members, I'm just going to give you some numbers before I move on here, but since this law has been in effect in the first year and a half, 280 individuals who were found to pose a significant risk, petitions were ordered for those individuals, and we're talking about situations that involved credible threats to schools and daycares. We're talking about individuals that were discussing workplace violence or confrontations with law enforcement. Put in short, this law saved lives, and it will continue to save lives. The updates that we're asking to put into effect going into the new year would save more lives, because we're making modifications that practitioners have told us could create barriers that prevent from saving more lives. This is a good amendment, and I do understand we tried to bring this amendment to the floor to calendar it for a direct vote. I was told that there's still some conversation that need to be had by some of my GOP colleagues. So what I'm saying by bringing this amendment to my GOP colleagues, it is okay to vote for something that will save lives. We've had many debates about gun safety in this chamber. This is something that we all can vote for, and we could put it in effect, make it stronger, and save more lives. We can show the rest of the state that we all agree that when we do something, when we put our minds to it, and we use our election certificates, that we can save lives when it comes to gun violence. This amendment would do exactly that. I do understand that this will be challenged and likely ruled procedurally out of order. So with that, I wanted to share what this law has done, what it will continue to do, but that we can absolutely make it better. But with that, I will withdraw my motion.
Representative Frazier withdraws his amendment. There are no further amendments at the desk. The chief clerk will give the bill its third reading.
Third reading, Senate File Number 4760, as amended.
Third reading. Discussion to the bill as amended. I recognize the member from Ramsey, Representative Moeller.
Just again recommend a yes vote. Thanks again, Chair Novotny.
I recognize the member from Sherburne, Representative Novotny.
Thank you, Mr. Speaker, and just to thank Chair Moeller and our staff that helped put us together. We probably will have one more bill that we will bring to the floor, so we'll do our thank yous extensively at that point. Just point out, there's nothing in this bill that was horse traded. These are all bills that we both supported and has had widespread support from bipartisan bills. I appreciate a green vote.
Seeing no further discussion, the clerk will take the roll. Can we switch? The clerk will call the names of the members voting remotely.
Green.
Green votes yes.
Green votes aye. McDonald.
McDonald, aye.
McDonald votes aye. Momani Hiltsley.
Momani Hiltsley, aye.
Momani Hiltsley votes aye. Perez Vega.
Perez Vega, aye.
Perez Vega votes aye.
The clerk will close the roll. There being 116 yeas and 16 nays, the bill is passed as amended and its title agreed to.
The next bill on the calendar for today is Senate File 2971. The clerk will report the bill.
Senate File number 2971, an act relating to transportation, requiring data collection on bridge-related suicides, the first engrossment.
I recognize the member from Martin, Representative Olson, to explain the bill.
Thank you, Madam Speaker and members. It was about a dozen years ago that every other day for 4 years during my military training with the University of Minnesota, I would run across the Washington Avenue Bridge. And every single time I ran across that bridge, I looked over and I said, wow, that's a really, really short railing. So much so that I would always ensure that I ran on the inside of the pack of soldiers as we went across the bridge. And this is from a guy who's not really scared of heights. Now, members, that was more than a dozen years ago. And that bridge just got covered a year ago. They estimate that 3 to 5 individuals per year committed suicide on that bridge for 50 years. Members, this is a problem. And this is something that the state of Minnesota can do something about. This is something that the Department of Transportation can do something about. What this bill does, what this Senate file will do, is it will tell the Department of Transportation that you need to do a study, collect data, and come up with best practices for the creation and the renovation of bridges in our state. Infrastructure in our state that we, the people, own, need to ensure that they're safe for individuals. Because, members, studies have shown that if a person going across a bridge who's in a bad place can make it across that bridge, chances are we can save their life. That's what we need to do, and that's what this bill here does today. Members, this bill was inspired by an individual named Kayla, and her mom's up here in the gallery today. MJ's here, and she wanted to thank all of you for the support that you've shown in combating suicide. Now, you all know that this is a very meaningful issue to me. It means something to me both as a soldier but also as a person who lives in this state. Suicide touches many lives, and MJ wanted you all to know that there is, in fact, help. So if you are in a place or you know someone who is in a dark place, encourage them to seek help because help is there. Members, this is one way that we can save lives. It is blatantly obvious. It's right there in front of us. We can save lives today by telling the department, collect the data, create the best practices, and let's build and renovate bridges in our state in a way that saves lives. Thank you, Madam Speaker.
There are no amendments at the desk. The clerk will give the bill its third reading.
Third reading, Senate File number 2171.
Third reading. Further discussion to the bill. I recognize a member from Dakota, Representative Hansen R.
Thank you, Madam Speaker. And first off, our hearts go out to people who've lost people at the bridges throughout our state. As Representative Olson mentioned, it took a while for the Washington Avenue Bridge to get fixed. A little closer to home and to the Capitol, the High Bridge in St. Paul. There was a response because of so many people being lost on that bridge that immediately the barriers went up. We can't be reacting to each bridge we have to be planning and preparing. And so I think the beauty of this bill is doing that assessment, looking at the data, finding where those bridges are that have a high propensity for people to use them. I think, again, close to home here, the Mendota Bridge, I think about that. Actually, whenever I drive across that bridge. And so having that data collection is important, and then looking at how's the best way, you know, maybe as those bridges are designed, we have old bridges, we have new bridges. It's kind of amazing we haven't thought about this before in trying to design in protection and prevention. And having those best practices, and then where can we do the best work first? How can we respond quickly? So I would encourage a yes vote to this bill. I think it is a part of a journey that began over the last few years on trying to deal with bridge suicides. I think that this is an important key, and it's a key that has been taken all the way to Washington, D.C., so it's not just Minnesota who's looking at this. It's throughout the country. How can we do things better? How can we prepare and protect our people? So please vote yes.
I recognize the member from Lyon, Representative Swedzinski.
Thank you, Madam Speaker. Thank you, members. I want to thank Representative Olson for this bill. You know, I think as you spend time in St. Paul, you see a lot of things. And my experience in this particular area was on the Marion Street Bridge. I was crossing, came up the exit, and as I passed by the Capitol Ridge and off to my right, over Highway 94, was a young man holding onto the pole backwards like this. He was leaning over the top. He was on the outside of the railing, leaning over traffic, staring down semis as they drove underneath as I was stopped right next to him. And I rolled my window down and I said, "Do not do it." And he turned to me with hurt in his eyes. We can't be there for every single person that is contemplating suicide. That man jumped the fence and kind of ran after my car after that, but he didn't do what he was contemplating at that moment. And, you know, as we contemplate these things, we can't always be there, but there are things that we can at least look at. And I want to thank Representative Olson for carrying this bill. I want to thank all the members that I know will support it as it moves forward. But as we think about that guy. I don't know where he is at. I drove around the block, went into Capitol Ridge, and watched him from the lobby, and I saw him walk up the street. Then he went up into the St. Paul campus, the college right there by the cathedral, and he went about his day, I think. So that's my story. Vote yes.
I recognize a member from Clay, Representative Keeler.
Thank you. I just want to start by saying 988 is the suicide hotline. As we talk about this, it is really, really important that we know that there are supports. I say it every time at the Health Committee. I say it every space that we are. 988 is a suicide hotline. I have, would the author yield for a question, please?
Representative Olson will yield. Representative Keeler.
I feel like I can't see him, and it's weird to ask a question and not see the author. Hi. As a member who represents the border of Minnesota, we have a river. And so my question is, in this language, it says it needs to be a Minnesota bridge. Is it that both ends of the bridge are in Minnesota, or would this data be collected on our border city bridges as well?
Representative Olson.
Well, thank you, Madam Speaker, and thank you, Representative Keeler, for the question, and also thank you for the heads up earlier so I could get you the actual answer for this. From what we found is that when you're talking about cross-border bridges, we have agreements with other states, and so it would depend on how Minnesota and North Dakota agree when you're talking about building the bridge, when you're talking about renovating a bridge. North Dakota's agreement with Minnesota on how to fund it, but Minnesota Department of Transportation will be collecting all the information from all the bridges that we are working on, all the bridges that we possess or own in some kind.
Representative Keeler.
Thank you. Follow up, would the author continue to answer?
The author will. Representative Keeler.
Thank you. So do we take into mutual aid agreements at all in this prospect? Because when we think about suicide response, we lean into our public safety response mechanism. Moorhead, I know, has a mutual aid agreement with Fargo. Would we fall in line with being part of this data?
Representative Olson.
So the department's going to be the one who compiles this data. It's something that we could potentially, I'll talk with the chair of the Transportation Committee. We can continue to form and work on this as we go, but I think that's a great question. But we're giving the department some latitude when they collect the data as to how they do it. And so I can speak with them and ensure that that's on the docket for what they work with.
Representative Keeler.
Thank you. I really appreciate that, and anything that we can do, I know we still have time to make changes. This would be a really meaningful change. It's something that we know in our community. And again, being a state that's surrounded by water, I just think it would be really important. Would be happy to lean into this. Thank you.
Any further discussion? I recognize the member from Dakota, Representative Kosnick.
Thank you, Madam Speaker. Members, from time to time, it makes sense to review our design standards and refine them if needed, because over time, things kind of change as they have here. And so it's an important issue, obviously, as we've heard from more members than I thought would speak on this. But it is an important issue, so thank you, Representative Hansen, for working and bringing your bill last year and allowing me to co-author and put that in the transportation bill in regards to the bridge that Representative Olson referenced, the Washington Avenue Bridge, and we've created some funding streams to make that particular specific bridge safer for the students and those that use that bridge. But this is a little bit more broad, and I think it addresses an important need. So thank you, Representative Hansen. Thank you, Representative Olson, for carrying this bill, and Senator Dibble in the Senate on the other side for the work on this and continuing to do that. Surprisingly, last year in the transportation bill, when we addressed the Washington Avenue bridge, that was, for some reason, got one of the most contentious parts of the bill, and I don't know why. But I'm glad we got that important work done. And then I also want to thank Representative Olson and the authors for working with MnDOT and MnDOT specifically for agreeing to take a look at this, refine the standards, and use existing resources so that there aren't additional expenditures contained within this bill that I thought was important, because it's part of what MnDOT should be doing is revising these standards with the resources that they currently have as part of their ongoing work. So great work on this bill, and it is very important, even though it might not be a marquee bill that we passed this year, but it is very important for those affected, and great work for everybody that's supporting it. Thank you, Representative Olson.
Any further discussion? Representative Olson.
Thank you, Madam Speaker. Thank you, members. Kayla's mother says that she lost her daughter, Kayla, to suicide on November 9th, 2023. That pain will stay with her forever. But through that heartbreak, Kayla's story has helped create meaningful change. Above all else, this bill is a reminder that suicide is preventable and that her daughter's legacy now lives on in every life that may be saved because of this bill, your efforts, and your votes. Members, please vote today for Kayla's Hope Act. Thank you, Madam Speaker.
The clerk will take the roll. The clerk will call the names of the members participating remotely.
Green.
Green votes aye.
Green votes aye. McDonald.
McDonald, aye.
McDonald votes aye. Momani Hiltsley.
Momani Hiltzley, aye.
Momani Hiltzley votes aye. Perez Vega.
Perez Vega, aye.
Perez Vega votes aye.
The clerk will close the roll. There being 134 ayes and 0 nays, the bill is passed and its title is agreed to. The next bill on the calendar for today is Senate File 3888. The clerk will report the bill.
Senate File number 3888, an act relating to transportation, permitting tow trucks to use variable message signs.
I recognize the member from Anoka, Representative Koegel, who will explain the bill.
Thank you, Madam Speaker. Senate File 3888 is the tow truck permitted to use variable signs. This is just technology on the back of tow trucks that says slow, move over, has some arrows going. So they're pre-programmed messages that will display, and according to the AAA Foundation for Traffic Safety, odds of a vehicle moving over were over 95% higher when the vehicle-mounted variable messaging signs were used. And so this is permissive language to allow tow trucks to have these messages on their vehicles and also sets up standards for these messages. So it's a good bill, vote yes.
There are no amendments at the desk. The clerk will give the bill its third reading.
Third reading, Senate File number 3888.
Third reading. Discussion to the bill. I recognize Representative Lawrence.
Thank you, Madam Speaker. And I wasn't going to say anything, but I had a friend of mine that brought this issue to me earlier in the year. And I just want to say thank you for coming with a good solution and bringing it forward to the House floor. And I'll be able to take it back to him that something was done to help make tow trucks, the drivers, in a safer position when they're on the roadway assisting disabled vehicles and individuals. Thank you.
Further discussion to the bill. I recognize the author, Representative Koegel.
Thank you, Madam Speaker. And members, if you see emergency lights on the side of the road, move over. That's also a message to all Minnesotans. If you see those lights, move over. It is illegal. And so move over when you see these lights. And hopefully this will be a reminder for folks to do that. So to keep the folks on the sides of the roads who are in unfortunate situations safe. So thank you very much.
The clerk will take the roll. The clerk will call the names of the members participating remotely.
Green.
Green votes aye.
Green votes aye. McDonald.
McDonald, aye.
McDonald votes aye. Momani Hiltzley.
Momani Hiltzley, aye.
Momani Hiltzley votes aye. Perez Vega.
Aye.
Perez Vega votes aye.
The clerk will close the roll. There being 134 ayes and 0 nays, the bill is passed and its title is agreed to. The next bill on the calendar for today is House File 4063. The clerk will report the bill.
House File number 4063, an act relating to transportation, modifying stopping requirements for vehicles approaching school buses.
I recognize the member from Carver, Representative Rehm, to explain the bill.
Thank you, Madam Speaker. So House File 4063 is a DPS policy bill, which is mostly made of duplicative language to the bill that was passed earlier this year and made into law, Representative Keith Allen's bill on school bus safety. And I do have an amendment to add.
There's an amendment at the desk. The clerk will report the amendment.
Rehm moves to amend House File number 4063, the first engrossment. The amendment is coded 0113.
I recognize Representative Rehm to your amendment.
Thank you, Madam Speaker. So the revisor's office knows that there would be a little bit of problem if we kept the current language in House File 4063, and I did speak with the bill's author of the school bus safety bill previous, Representative Keith Allen. Is a friendly amendment. It just helps to avoid any confusion and helps conform this bill to the bill that was passed earlier this year.
Discussion to the amendment. I recognize the member from Goodhue, Representative Allen.
Thank you, Madam Speaker, and thank you to Representative Rehm for putting this in, and thank you to the revisers for catching this little bit of a typo. It's greatly appreciated, and like she said, this is a friendly amendment, and I urge its passage. Thank you.
Any further discussion to the amendment? All those in favor say aye. Those opposed, nay. The amendment is adopted. The clerk will give the bill its third reading as amended.
Third reading, House File number 4063, as amended.
Third reading. Further discussion to the bill. I recognize the author, Representative Rehm.
Thank you, Madam Speaker. So I'm going to highlight a couple things from this school bus safety package. As we have previously stated, this is a school bus stop arm violation bill is included in here, which was passed earlier this year. There's also a proposal for Type 3 school bus first aid kits. Type 3 buses are currently required to carry a 10-unit first aid kit, and this requirement is a bit outdated. It misses essential supplies and is inconsistent with best practices. So the proposal here would require best practice first aid kits in all buses that would conform with the national recommendation standards. Also, USDOT numbers for school buses. We have a proposal for that. Right now, Minnesota exempts school buses from obtaining USDOT numbers. However, most school buses already have one. The Minnesota State Patrol is legislatively mandated to inspect all school buses. And this proposal would require all school buses to have a USDOT number. The change would only affect a small number of buses, a very friendly proposal, I believe. And then the last thing here is a school bus used for training. So right now, buses, when they're on private roads, it's not legal for them to be doing any training on these roads. So this proposal would allow behind-the-wheel training in school buses on private roads. Buses would be labeled plainly as student driver, and licensed commercial driving schools would be allowed to use those buses on public roads for training purposes. So thank you.
There being no further discussion, the clerk will take the roll on the bill. The clerk will call the names of the members participating remotely.
Green.
Green votes aye.
Green votes aye. McDonald.
McDonald, aye.
McDonald votes aye. Momani Hildsley.
Momani Hildsley, aye.
Momani Hildsley votes aye. Perez Vega.
Go ahead.
Perez Vega, aye.
Perez Vega votes aye.
The clerk will close the roll. There being 134 ayes and 0 nays, the bill is passed as amended and its title is agreed to. The next bill on the calendar for today is House File 3709. The clerk will report the bill.
House File Number 3709, an act relating to financial institutions allowing certain virtual currency custody services to be offered and performed.
I recognize the member from Stearns, Representative Perryman, to explain your bill.
Thank you, Madam Chair. HF 3709 is basically a bill that allows Minnesota banks and credit unions to provide virtual currency custody services. Say that real fast, but currency custody services. This is a great bill because it was worked on by myself, Representative Elkins, Representative Allen, and I had a lot of help from the Commerce Department, so they approved this as well, and it did pass in the Senate omnibus yesterday. So we're on our way here. House File 3709 is about a simple, important question, and I'll bet you ask yourself every morning, where should Minnesotans safely store digital assets they already own? I bet you ask yourself every morning that. Regardless of your personal feelings on digital assets, it is understandable that Americans have a strong interest in investing in cryptocurrencies and other digital assets. At least 14% of Americans reported having invested in crypto in 2025. This bill is not about endorsing speculation or chasing trends right now about cryptocurrency. Right now, there is too many consumers who are forced to rely on unregulated, out-of-state, or offshore platforms that operate outside Minnesota law and outside meaningful oversight. This legislation brings digital asset custody into our regulated financial system, along with local banks and credit unions, to offer custodial accounts limited strictly to safekeeping and administration. These institutions are not speculating, trading, or putting consumer assets at risk. They are doing what they already do well, safeguarding assets under strong safety and soundness standards overseen by regulators. From a consumer protection standpoint, the question is simple. Do you want Minnesotans relying on lightly regulated exchanges or trusted local institutions overseen by the Department of Commerce? The bill chooses regulation, disclosure, segregation of assets, and examiner oversight over the status quo of risk and opacity. HF 3709 also helps keep money and economic activity local here in our state. When Minnesotans are forced to use national or offshore platforms, deposits and investments dollars leave our communities. Allowing trusting local banks and credit to offer custody services helps retain relationships, strengthen local balance sheets, and ensure capital continues to support Minnesota businesses and families. Finally, the Minnesota Department of Commerce, which oversees all state chartered banks and credit unions, retains full authority to step in if an institution operates in an unsafe or unsound manner. Also, the banks and credit unions do have to apply to the Department of Commerce in order to start this program. And this program is not mandated. Banks or credit unions may choose to do it as a service to their customers or not. It's not mandated. This is not a free pass. It is prudent, carefully limited framework that balances innovation and responsibility. Members, this bill is not about promoting digital assets. Many people are understandable skeptical of the volatility of cryptocurrencies right now and other digital assets. This bill does not open our local banks and credit unions to any new risk or jeopardizes people's checking or savings account. Instead, this bill is about meeting Minnesotans that do have interest in these assets and where they are, giving them more security and surely while protecting consumers, strengthening protecting local institutions, and keeping Minnesota competitive and secure within the financial institutions. Members, I urge a green vote and your support.
There are no amendments at the desk. The clerk will give the bill its third reading.
Third reading, House File number 3709.
Third reading. Discussion to the bill. I recognize the member from Hennepin, Representative Elkins.
Thank you, Madam Speaker. I have had friends that have misplaced their crypto account credentials and effectively lost everything that they had wagered in crypto. That wouldn't happen if you were able to keep your crypto assets in the custody of your bank where you would know where it is, and if you lost your own credentials, it could be found. It would be extremely important to your heirs if you died with a crypto account and they had no way of knowing, how that these assets existed. So this is a good bill. Please vote yes.
Further discussion to the bill. Representative Perryman.
Thank you, Madam Chair and all members. Digital assets are not going away. The real question for Minnesota is whether our local financial institutions will be allowed to safely participate in this emerging financial infrastructure, or whether Minnesotans will be forced to rely entirely on large national technology platforms which are out-of-state institutions. This bill creates a clear regulatory pathway for Minnesota credit unions and community financial institutions to provide digital assets, custody services under proper oversight. That keeps innovation, liquidity, and consumer protection right here in our state of Minnesota. HF 3709 ensures Minnesota does not fall behind the evolving financial system. It protects consumers, strengthens local institutions, and allows innovation to occur under the proper regulatory oversight. The goal is simple. Give Minnesota the ability to work with trusted local financial institutions in the digital asset economy rather than forcing them to rely solely on large national platforms. I thank you, and I look forward to a lit-up green board.
The clerk will take the roll. The clerk will call the names of the members participating remotely.
Green.
Green votes green.
Green votes aye. McDonald.
McDonald, aye.
McDonald votes aye. Momani Hildsley.
Momani Hildsley, aye.
Momani Hildsley votes aye. Perez Vega.
Go ahead.
Perez Vega, aye.
Perez Vega votes aye.
The clerk will close the roll. There being 130 ayes and 4 nays, the bill is passed and its title is agreed to. The next bill on the calendar for today is Senate File 4171. The clerk will report the bill.
Senate File number 4171, an act relating to housing, providing for submetered utility services, final billing for vacant tenants.
There are amendments at the desk. I will go to the author, the representative from Itasca, Representative Igo, to explain the bill.
Thank you, Madam Speaker. Members, this is a pretty straightforward bill in front of us today, and there is going to be some amendments, but I'll present the first part of the bill. So this bill permits shared metered residential buildings to bill utilities for the last billing period before a tenant vacates based on estimations. It's also going to require landlords to offer digital payment of rent to provide alternative methods of payment if they can't afford or if they can't figure out how to use the digital methods. It also is going to prohibit additional fees beyond admin and late fees for these services. So it's kind of a cleanup bill to kind of help streamline how our landlords and tenants interact with each other. But again, there's going to be a few amendments that were agreed on through working with the multiple stakeholders that work in landlord-tenant law. So I think it's best if we get to those amendments, we have some discussion on that, and then I'll give a final presentation on how we got to this bill. Thank you.
There's an amendment at the desk. The clerk will report the amendment.
Dotseth moves to amend Senate File number 4171, the first engrossment. The amendment is coded A2.
Thank you, Madam Chair. Members.
I recognize the member from Carlton, Representative Dotson, to your amendment.
Thank you, Madam Chair. Members, I rise to speak to the A2 amendment, Senate File 4171. The amendment closes a clear gap in the current law by expanding language from residents to include landlord and landlord's employee and contractors. Right now, expedited eviction is only available when one resident endangers another, but at the same time, threat is direct at maintenance workers, property managers, or contractors. There is no expedited path in this act. That doesn't reflect how apartment communicates exactly functions in shared environments, hallways, parking lots, stairwells, where residents, staff, and visitors interact every day. When there is a serious safety threat, it affects everyone at the property. This amendment allows expedited actions when a resident threatens or harms anyone present, not just another tenant, while still maintaining strong safeguards, a sworn affidavit with specific facts, judiciary review, tenant right, tenant service timelines, and penalties for misuse. This is a targeted, common sense fix that improves safety without overreach. Members, everyone deserves to feel safe where they live and where they work. I urge you to adopt Amendment A2.
Discussion to the amendment. I recognize the member from Hennepin, Representative Howard.
Members, I would encourage a yes vote. This is one of the amendments that's part of our agreement on this landlord-tenant package. Specifically in this one, I want to call out the work of Representative Agbaje and Representative Kozlowski for working to tighten up this language in a way that we're more comfortable with. I would encourage a yes vote.
Any further? I recognize Representative Igo.
Thank you, Madam Speaker. Yes, just want to add this is, again, a good amendment. Simply put, everyone deserves to be safe at home, and this amendment is going to help us make sure that tenants across our state can continue to feel safe at home. I encourage a yes vote.
All those in favor of the amendment say aye. Those opposed, nay. The motion prevails and the amendment is adopted. There's an amendment at the desk. The clerk will report the amendment.
Hussein moves to amend Senate File number 4171, the first engrossment. The amendment is coded A1.
I recognize the member from Ramsey, Representative Hussein.
Thank you, Madam Speaker. This is a friendly amendment that's been supported both chairs, Representative Igo and Howard. This amendment does protect minor children not to be in eviction case. And we have seen so many cases that a lot of people don't know whether they have eviction until they become 18 years old. So this will protect and not to be in their records. So it's clear and short, and it comes with penalty. any landlords that are not complying with this law. And I urge for you to support this great amendment so we can protect our children.
Further discussion to the amendment. Representative Igo.
Thank you, Madam Speaker. Members, again, this goes to some of the discussions we've had with stakeholders and working with Representative Hussein, Chair Howard, and myself. This is a good amendment to fix some stuff in statute to, once again, not only look out for tenants, but look out for future tenants of the state of Minnesota. I encourage a yes vote.
All those in favor, say aye. Those opposed, nay. The motion prevails and the amendment is adopted. There are no further amendments at the desk. The clerk will give the bill its third reading as amended.
Third reading, Senate File Number 4171, as amended.
Third reading. Further discussion to the bill. I recognize a member from Hennepin, Representative Howard.
Members, I'll be quick. I just want to thank members on our committee, both sides of the aisle, for their work. This is a very small, skinny tenant-landlord bill this year, but we have 3 provisions that we worked on together, came to agreement that are important steps forward in this work. And I also want to thank some of our tenant rights advocates and also folks with Minnesota Multi-Housing for their partnership in these areas. Landlord-tenant law is not the easiest area for us to find common ground, but we have done that with these 3 provisions this year. It's a good bill, and I encourage a yes vote.
I recognize the member from Itasca, Representative Igo.
Thank you, Madam Speaker. Members, similar thanks. Thank you to the Housing Committee, but also thank you to the Judiciary Committee for their work in getting these ironed out. Whereas this landlord-tenant bill might be small, I think it represents some incredible bipartisan work to take issues that we all found concerns about and work together to find a way to get them all pulled together here in the final moments. I want to thank again the advocates like Homeline, Legal Aid, and Minnesota Multi-Housing for working with all of us members, and a special thanks to Representative Hussein and Representative Dotseth, who really did a lot of work to make sure these amendments were in a place today to put into this bill. So this has really turned into a great little package, a bipartisan package that's going to make the lives of landlords and tenants better in the state of Minnesota. Thank you.
The clerk will take the roll. The clerk will call the names of the members participating remotely.
Green.
Green votes aye.
Green votes aye. McDonald.
McDonald, aye.
McDonald votes aye. Momani Hiltsley.
Momani Hiltsley, aye.
Momani Hiltsley votes aye. Perez Vega.
Go ahead.
Perez Vega, aye.
Perez Vega votes aye.
The clerk will close the roll. There being 134 ayes and 0 nays, the bill is passed as amended and its title is agreed to. The next bill on the calendar for today is Senate File 1750. The clerk will report the bill.
Senate File Number 1750, an act relating to common interest communities, modifying powers and duties of common interest communities.
I recognize the member from Hennepin, Representative Bahner, to explain the bill.
Thank you, members. Today, we are here to discuss the Homeowners Bill of Rights. The document before you refines and reforms our 32-year-old statute to provide much-needed updates for those living in home ownership communities and common interest communities. The Homeowners Bill of Rights focuses on 3 main things: transparency, best practices, paired with strong consumer protections. With 82% of new homes entering the marketplace in an HOA and nearly 1 in 4 Minnesotans living in an HOA today. As CICs and HOAs increase nationally and at home, our laws have simply not kept pace. And in some cases, we have unfortunately experienced what appears to be the Wild West. But red states and blue states such as Illinois, Florida, and most recently Georgia acknowledge the greater need for basic guardrails around transparency, best practice, and consumer protections. Catch a theme. Legislators in this room know that it is one of our most frequent constituent concerns and one of the hardest to remedy, as Minnesota statute offers little relief. The stories many of you have heard here are about when a homeowner's dream turns into their worst nightmare. But the bill before you seeks to fix that. It is the culmination of a deep dive spanning years that began with a work group to tackle thorny issues around this topic, and passionate public listening sessions in every corner of the Twin Cities, pulling folks from greater Minnesota in. Since that time, the bill has received robust review with a wide array of stakeholders and has seen significant revisions to add flexibility and clarity while also balancing the needs of very different groups of stakeholders, as you can imagine. It has passed the Senate with a bipartisan supermajority, and the current bill also has includes technical fixes that you will have coming up and some additional final clarity to prep it for the floor and move it towards a neutral position. But the final version before you will reflect the intense negotiations, compromise that has brought this to be an incredibly strong bill. And with that, I will head to the next piece. Thank you.
There's an amendment at the desk. The clerk will report the amendment.
Bahner moves to amend Senate File Number 1750, the second unofficial engrossment. The amendment is coded A5.
I recognize the member from Hennepin, Representative Bahner, to your amendment.
Thank you. The A5 is, as I just mentioned, this is the culmination of those last-minute touches to make sure that the periods are in the right place, the commas are in the right place. If there's a word missing, that kind of fun technical thing to prepare it for the floor. So it is primarily about technical corrections and clarifying language to prepare for final passage. It does have a few things, and I'll just list a few rather than go through the entire list to spare you all the detail. But I will give you a highlight of a couple of the more substantive things that you will see in here. For example, on page 13, you will notice that it provides that a notice may be distributed in any reasonable manner. That will reduce costs so folks can actually do that electronically should they so choose. It also suggests on page 15, the unit owner has the right to be advised by an attorney. That originally was they have a right to have an attorney present, but it was suggested that that might trigger the HOA's need for having an attorney as well. And we want to keep costs down for all parties concerned. So then also making sure that when you send out or a final decision is made on an issue before the board, that a final decision to relevant folks is distributed within 30 days of adoption, fairly straightforward and reasonable. And then, of course, we have that an association may not refuse acceptance of a payment from an owner, and it prescribes some additional information to clarify how that allocation of payments should be made. It also clarifies some language on elections to make sure that that piece is as crisp and clear as possible, as this document will likely be read by lay people, including volunteer boards. It also clarifies the information about documents being made available to individuals and homeowners before meetings. It also adds some clarifications around records being available for inspection. So that is nice and tidy. And finally, it adds some clarity on when you need to give notice of a referral to an attorney. The lawyers like to make sure we have those details accurate. And then, of course, we have, lastly, a statement of obligation that sort of outlines for homeowners when they're purchasing that first home what their obligations may be under an HOA. Those are the highlights of the A5. Thank you.
There is an amendment to the amendment. The chief clerk will report the amendment to the amendment.
Gottfried moves to amend the Bahner amendment to Senate File number 1750, the second unofficial engrossment. The amendment to the amendment is coded A14.
I recognize the member from Ramsey, Representative Gottfried, to explain your amendment to the amendment.
Thank you, Madam Speaker. And this amendment we'd originally worked on because one of my constituents reached out with an issue. She's a participant in the Safe at Home program and had her HOA basically reveal her private data to a whole bunch of third-party vendors, and then it got aggregated from there on out. I know Representative Keeler also had a constituent where this was also a problem for her, and her Representative Keeler's amendment will also address this. The original amendment we drafted, we realized had some issues and that it had some adverse interactions actually with the Safe at Home program. So we worked with the Secretary of State's office to make sure that there was no confusing or adverse interactions between what we're intending to put within this bill and that Safe at Home program. So this amendment is pretty simple. It specifies that an association or management company should not sell their residents' private data, and if they must, for an express business purpose, they must ensure that the vendors to whom they sell that data cannot then in turn go ahead and sell that resident's data to others. As I said, interestingly, this issue for both my constituent and Representative Keeler's constituent popped up within a matter of weeks of each other. And if it's okay with the Speaker, I would like to take a moment to share the experience of my constituent. With her permission, that inspired this particular amendment. So these are her words. As a homeowner in Roseville and a participant in the Safe at Home program, I took the necessary steps to protect my identity and ensure my home remained a place of safety. I provided my HOA and its management company with the required documentation, trusting that my private information would be handled appropriately. Instead, my name and address have been repeatedly exposed, shared in homeowners' portals, listed in directories, and published in meeting minutes. At the same time, my data has been shared with third-party vendors without my knowledge or consent, leaving me with no control over how it is used or further distributed. Standard HOA governing documents also allow board members and vendors to enter properties and photograph homes, potentially capturing sensitive details like entry points, while volunteer board members are permitted to store this information on personal devices with no clear safeguards or accountability. For me, and for other survivors of domestic violence and our families, this is not just frustrating, it is dangerous. The Safe at Home program exists to prevent exactly this kind of exposure, yet living in an HOA has forced me into a position where my safety is compromised just to maintain my rights as a homeowner. The emotional toll is significant. I have gone from feeling secure in my home to constantly questioning who has access to my information and whether it has already been shared beyond my control. My home should be a place of stability and protection, not a source of fear. Without clear data privacy protections, limits on information sharing, and accountability for violations, Safe at Home participants like me are left vulnerable in the very communities we are supposed to feel the safest. And for very obvious reasons, my constituent asked that her name be kept private in this testimony. This A14 amendment provides exactly the data privacy protections and clarifications that would preserve the security of my constituents, many of your constituents, Safe at Home participants, anyone living under an HOA, and maybe even members of this body here. I would ask that you put yourself into my constituent's shoes, into Representative Keeler's constituent shoes when she shares that story. And I think it shouldn't be too difficult at this point, because at this point, every single person in this room knows what it feels like to be targeted. Every single one does. And so, I would ask, whether you live in an HOA or not, Would you like to have your name and address sold to a third party or a vendor who then in turn can do the same and sell it to data brokers and Lord knows how many other entities? This amendment fills the gap that currently exists in this HOA bill, identified by real people in our communities. And I just got a question. If this happened in Roseville and in Moorhead, how many other places in our state is this happening? And, you know, in conversations that I had even just earlier today, you know, as certain municipalities are requiring HOAs to be organized, how much more often is this going to happen? And, you know, in a world where we are increasingly subjected to surveillance and our privacy infringed upon by anybody who is willing to pay enough money, these types of provisions are necessary not just for HOA members, but for everyone in our state, especially survivors of domestic violence, sexual assault, and abuse. Passing this amendment is the right thing to do to shore up this bill. Thank you, Speaker. I would ask for a roll call, and please
A roll call
ask.
has been requested. Seeing 15 hands, there will be a roll call. Representative Godfrey.
Thank you, Madam Speaker. I ask for a roll call, and please ask for your support. This is the right thing to do to shore up the data privacy for literally everyone that is under an HOA. Thank you.
Discussion. I recognize Representative Scott.
Thank you, Madam Speaker, and thank you, Representative, for this well-intentioned amendment, and thank you for the conversation that we had outside of the chamber on this. And my concern is your amendment isn't just about selling the information, it's about disclosing the name and address. And so I just want members to imagine that you are an HOA member in a multi-level condo building, and there's a leak, there's a plumbing leak, and don't know the source of it, it's affecting multiple units. And it's rather an urgent issue. So under this amendment, Representative, would the management company not have to have, okay, there's an express business purpose to take care of this leak right away. And would Representative Gottfield yield for a question?
Representative Gottfield will yield. Representative Scott.
Thank you, Madam Speaker, and thank you, Representative. So in a situation like that, where it's kind of urgent, a plumber needs to address this issue quickly before it causes other issues, worse issues. If they don't have a signed written agreement already, and okay, keep in mind that this company might be trying to find the most available plumber right now that there is, but they don't have a signed written agreement with said plumbing company. So what would they need to do to take care of this problem, especially if it's during business hours, nobody's home, they can't get the signatures? What would your bill, you know, that's where your bill to me is problematic, but help me understand how it wouldn't be.
Representative Gottfried.
Thank you, Madam Speaker, and thank you for the question, Chair Scott. So under this, it says on lines 1.8 that or 1.7 through 1.8, the Association of Property Management Company must retain an agreement from a third party or vendor that they shall not disclose or sell information of the unit's owner or occupants without express written permission. Now, there's a couple ways that I think your issue could be addressed. The first one is that very likely HOAs actually have preferred vendors where they could set these things up in advance. The second part of this is there could be boilerplate agreements that they have on file ready to go such that they could call one that is not a preferred vendor, or if the preferred vendor is not ready or not available at that time, that they could have fill out that agreement between the management company and or the HOA and that other vendor that they have called in to address this urgent issue, such that they could then have that agreement established upon the arrival of that third-party vendor. So I frankly, I don't necessarily see this as too onerous a burden on the HOA or management company, because they have the ability to develop that language in front and to have that agreement made upon the arrival of the vendor.
Representative Scott.
Thank you, Madam Speaker, and thank you for that explanation. I don't think in practicality that it would work out that way all the time. There are some homeowners associations that might be 4 units. They may not have an on-record plumber. So I just think that this would run into problems, and I understand what you're getting at, and I think that this is a situation where we should work with the folks in the Safe at Home program and come up with a better solution, over the interim next year to put in place so that this doesn't happen in the future. But I think this isn't kind of a, I think it's too heavy. I think it's just too heavy of a solution for what we're trying to do. And I know if you talk to people that have worked on the Safe at Home program, these usually aren't fast fixes. It's complicated, right? It's complicated. And so I think this is something, I understand the intentions of this amendment, but I really do feel like it needs more vetting. I don't think that this is ready for prime time, and I would encourage a no vote, Madam Speaker. Thank you.
Further discussion to the amendment to the amendment. I recognize the member from Stearns, Representative O'Driscoll.
Thank you, Madam Speaker. Would the bill author, Representative Bahner, yield to a question, please?
Representative Bahner will yield. Representative O'Driscoll.
Thank you, Madam Speaker. Representative Bahner, we did not hear your recommendation on the amendment to the amendment, and I would be curious to hear what the bill author has to say about the amendment to the amendment.
Representative Bahner.
Well, thank you, Representative O'Driscoll. It just so happens I think I was next on the list. So I'd be happy to share my thoughts on that with you. I want to just point out that while the example given today was a pretty egregious one about Safe at Home, the underlying amendment, as I see it, isn't just about Safe at Home participants. It's about all of us, right? And the amendment that is before us today also falls under the duties for HOA board members. I think it's quite reasonable to expect that when you buy your home, that the folks who are in charge of your board are not giving out your personal information, your name, your address, your personal details, to folks who don't need it. I think this speaks to the basic tenet of data privacy. It speaks to the privacy that all of us need. And we shouldn't have to feel like we are being violated in our own homes. And it was said here that it's complicated. It's really not. There is no reason outside of exactly what we discussed here, a maintenance issue, for example, why you would need to be giving out the name and address of all your residents. There is no reason you would need to be giving out or selling the name and address of your residents. And I think most of us would agree that we don't want that data sold. Not only that, there's a larger implication here too when that information is released publicly or it is misused or abused. Each and every person in this room probably has a Delete Me account. We have it for a reason. We have it because a very large number of the people in this chamber have been targeted before. We had an experience just this last June in which the gunman used public data that he got off of a website somewhere through a data broker to get our names and addresses, to come to our homes, to surveil us, to watch us, and ultimately perpetrate an attack. We are talking about this particular instance because this is particularly egregious. These are people who have been the target of violence. I don't think there is anyone in this room that believes that is it acceptable for your HOA to be handing out your personal information and putting your personal safety in jeopardy. So it's not complicated at all. And while the issue is the example that came up was Safe at Home, this is a broader issue. Do you want people giving out your private data that shouldn't be having it? And I think that speaks much more to the core of this specific amendment. And frankly, your safety in your own home should never ever be up for debate. I feel it's reasonable to ask homeowners association members to make sure that they're protecting your own personal private information, and I would encourage folks to vote green.
Representative O'Driscoll.
Well, thank you, Madam Speaker and members. So Representative Bahner, I don't disagree with you. And this bill that we have before us is in 515B, the Common Interest Community Act in Minnesota, which became law on June 30th of 1994. As of a lot of work by this body that was assembled at that time. The more global question that I have for you and for this body is 514B the spot to be able to be codifying all this information? Because what you're talking about is calling out one type of form of housing. Well, what about people who rent? I don't see anything in here. We're just picking on people who live in homeowners associations. How about people who live in manufactured home parks? Wouldn't this be better being brought through a committee process and be discussed by a committee and brought forth as its own bill with the Secretary of State's office under the Safe at Home Act instead of trying to piecemeal this together? Where does it apply and where doesn't it? And this is not going to be codified in the election law. This is going to be codified in 515B. So somebody's going to have to be looking around to try to figure out where this is at. I don't think that the idea is a wrong idea. I just think it's misplaced. And I would ask that the amendment be withdrawn and that we actually look at doing this more globally and solve the problem instead of just taking bites around the edges. Ask yourselves, members, you're going to choose today which group is more important to protect and which isn't. And I just came up with three different forms of housing while I was sitting here listening to the testimony on here. Second question I have, and Madam Speaker, if Representative Godfrey would yield to a question.
Representative Godfrey will yield. Representative O'Driscoll.
Thank you, Madam Speaker and members. Representative Godfrey, you cited two situations where this has occurred. Again, since we haven't had the ability to hear from anybody in the homeowners association or the individuals that you've cited and secondarily cited through, you turned to Representative Keeler and said that she may have had a similar situation in Moorhead. So that's 2 out of the 6 million people that live in the state of Minnesota that we have an issue. Why don't we run this through the committee process and try to find the right answer? I would trust that Chair Nash and Chair Cleavorn, who deal with a lot of this stuff, or Chair Quam and others, would be well suited to deal with this issue. But again, we're going to pick winners and losers, and we're going to go through and put some halfway thought through on amendments towards the end of session, bill or amendment together on a bill that's an amendment to an amendment that's going into a bill. That does not address the global issue that both the bill author and the author of the amendment to the amendment have said is a global problem. Seems to me that if we're trusted with doing the people's business, we should do it in a diligent fashion and find out all persons who are in this situation. So as much as I appreciate the work and the intent on this, Representative Godfrey, can you discuss why you don't think this should go through and why this group is much more important than the other members or forms of housing and folks who may occupy that type of dwelling?
Representative Godfrey.
Excuse me. Thank you, Madam Speaker. And thank you for the question. And I will say that there have been more folks affected by this than just the two people that I have referenced. I have had conversations with folks that work at a domestic violence organization that helps survivors of domestic violence, and this is a common occurrence for many of those folks who are involved in the Safe at Home program. And I know that Representative Bahner discussed how we are talking about the most kind of egregious example of this, survivors of violence having their data exposed. And I would reiterate what she said, is that this is an issue for all of us. None of us should want any of our private data leaked out to folks that we don't want it leaked out to. And to address your specific question about picking winners and losers, I think that is a false binary. I don't think that is the choice we're making, and I actually think it's I do think it's a disingenuous argument to make. And the reason why I say that is because this was identified through real world experiences. If we want to have a more global discussion about this next year during the committee process and things like that, and try to close this loophole for every single type of housing that exists, I'm all for it. Let's work together. Let's do that. But I think this is an issue that we have seen right here, right now, develop in front of our eyes within the past couple of weeks. And I don't know what we're supposed to be doing in this body if not being responsive to the needs of our constituents. And that's exactly what I'm doing right here. So to your point, if we want to work together, you mentioned a couple of representatives, Chair Quam over here, we can do this. Let's work with the Secretary of State's office to shore up the Safe at Home program going forward. This is something that I would like to do next year as well. But I do not think it's right to say that we're picking winners and losers here. No, we are simply responding to the needs of our constituents when they elevate these issues to us. Thank you, Madam Speaker.
Representative O'Driscoll.
Well, thank you, Madam Speaker and members. I'm very familiar with the Safe at Home program. As a matter of fact, I, in my legislative career, chaired the committee that had jurisdiction over elections and worked very closely with Secretary Simon and others. And given the nature of this and the sensitivity of this, I think it involves much deeper and much more conversation than just a passing on a Thursday afternoon before what I always call Legislative Friday, Thursdays around here, and people are saying, gosh, I wish I could go home. That's what we're up against, folks. We're saying, well, let's go protect this group or let's do this because we think it's a good idea. This is not how we should be making public policy around this place. We should be making public policy by bringing people in, by talking to people. And I have done some checking with the Secretary of State's office through our staff and through my team in the Commerce Department, actually in the Commerce Committee. And the Secretary of State's office is a little skittish about the whole concept of dealing with Safe at Home and how this is going to be dealt with, not necessarily in this specific amendment, but in the whole concept of a few other amendments that are coming up here. Members, really, if you want to do your job and you want to look people in the eye and say, I'm taking care of people, this is not the way to do this. Let's actually do it in a legitimate process. And don't tell me, folks, that we didn't have time to do it and stuff. This bill came to us 12 months ago from the Senate. And it's been in the House's possession for that long. And this bill got legs again. The underlying bill got legs again because I approached Representative Bahner and said, let's work on this bill and see if we can't get things squared away. I was surprised to learn that all of a sudden we're talking about Safe at Home with this. I'm not saying that we don't have issues here. I'm saying let's address the issue globally and not be here today picking winners and losers on a Thursday afternoon and dropping it in a bill in an obscure place in 515B for Safe at Home, which is a very, very legitimate and important program, and I have supported that and carried legislation and gave committee hearings to that topic. Let's do the right thing. Let's withdraw this amendment and others like it and get down to the issues that are on 515B and deal with those issues and that part of statute. I recommend, if we have to have this, a no vote. Clearly not on the concept, but on the process of taking a large, serious, as the amendment to the amendment author pointed out, can be a very, very life-death violent situation. But we're going to try to do it on an amendment to an amendment. Now, for those of you who are watching at home, and I doubt that there's a lot of you that are, an amendment to amendment, that's like grabbing onto shoestrings as the runner's running by you. Let's do the right thing. Out of respect for the people who this program is designed to protect, withdraw the amendment, not offer the other amendments that are similar to this, and deal with the 515B items that are before us in this bill. Thank you, Madam Speaker.
I recognize a member from Carver, Representative Nash.
Thanks, Madam Speaker. Members, if you'll remember, about a week and a half ago, we did a bill that I carried that was for the Safe at Home program. And Representative Gottfried, I appreciate what you're trying to get done here, but I want to tell you, well, first, my constituent thanks everybody very much for for the vote that we put on the floor that day. It passed off the Senate, and it's on the way to the governor. But that bill took about a year to get done from the time we brought the information to the Secretary of State till we met with all the different stakeholders. We met very closely with the Banking Association because there were things in there that required interaction with banks. We talked a lot about it with the Secretary of State. We went back and talked to stakeholders, and it was a long back and forth. And everybody eventually got to the point where they felt comfortable with it. And I don't believe that that's what's happened here. I'm happy to work with you and maybe share some of the experiences that I've had on getting safe at home stuff moving forward. But I know from having heard from the homeowners association folks that they have not really interacted with this at all. And I think that that was the lesson that I learned that was the most important in getting the bill that we just got done over the finish line, which is talk to all the people who will have a stake in the outcome. Now, there's a tremendous amount of merit here, Representative Gottfried, I'm happy to work with you. I will give you my personal cell number. We can talk over the interim. We can work on this together. I'm happy to do that. But what I know from having done the hard work of getting a bill first scoped out, that took a long time to make sure that we were threading the needle, working with the Secretary of State's office, letting them go back and think through things, then talking with the stakeholders, then having nonpartisan draft up the bill, and then we talked through that again. Then we went through the committee process, and I don't think this has gone through the committee process. In fact, I know it hasn't because it would have come to state government finance. I want us to have the ability to do the work the right way, and the right way includes making sure that you're talking to the stakeholders who will be impacted. And you've heard from Chair O'Driscoll, who's now off the floor. There he is. You've heard from Chair Scott. I don't think any of us are opposed to looking at how do we address this idea, because I will tell you that I'm committed to it. But there is a process. The process was not followed. And I don't want to vote no for your amendment, but if it goes to a vote, I'm going to vote no on it because it didn't really take the time to talk with the stakeholders so that they could get to a position of a mutual yes. And that's really the hallmark of a good piece of bipartisan legislation, is finding a way to get to a mutual yes on something that is as important as this. I don't want to create an adversarial relationship over something that is as sensitive and important as the safe at home, but the work wasn't done with the stakeholders, and I wish that it was, and I think that it needs to be. So I will ask members, if this goes to a vote, please vote no. It is not something that was brought to the attention of the homeowners association folks, and I know because I've gotten emails to that effect, and yet they're impacted, and we need to do that work. So with that, Madam Speaker, thank you very much.
I recognize the member from Anoka, Representative Scott.
Thank you, Madam Speaker. And Representative Gottfried, I don't know if you're aware of this or not, and maybe Representative Bahner can chime in here if she is aware or not aware, but in 515B, the homeowners association has to supply you, if you ask for the names and contact information of the other owners in that association, they have to provide that. Your amendment doesn't address that. So maybe there's someone within that association that's stalking a person or that is going to share that information. They can ask the homeowners association for all that information. They could sell it. They could share it outside the confines of the HOA. So again, I just want to iterate and reiterate that I think what you're doing here is well-intentioned. It's just not quite ready. I think it needs more discussion, and I would still encourage a no vote. Thank you, Madam Speaker.
I recognize the member from Hennepin, Representative Bahner.
Thank you. I appreciate it. I just want to be very clear. We've talked a lot about safe at home today, but I want to be very clear when you read the language, and you have it on a pink sheet, pretty easy to read. Nowhere on this pink sheet does it say safe at home. Doesn't say it. I just want to be crystal clear about that. This provision is not, well, that was one example given of why you might not want your data shared. That is not what this amendment does. This amendment is under the section entitled Powers and Duties of Unit Owners Associations. These are the people who run your homeowners association board. This is the section that outlines the roles and responsibilities of board members who are overseeing your homeowners association. So as to whether or not this fits here, it's exactly the right place to put it. We're telling homeowners associations and homeowners association board members what their roles and responsibilities are and what they can and cannot do. What we are telling them in this is that you should not be disclosing private sensitive information on your homeowners without an express business purpose or without consent. That is not complicated. It's not difficult. That's literally all it does. It says, hey, I'm on a homeowners board. I can't go around talking with folks and handing out the names and addresses of my members like they're candy. And I can't sell it. This is not complicated, folks. I just want to be clear. This bill, this paper, doesn't say anything about safe at home. There is an amendment coming on that, and you can certainly make all the arguments you want about safe at home when that amendment comes before us. But this amendment isn't that amendment. This amendment is about what the people who sit on a homeownership board can and can't do. It is exactly the right place for it. And if you think that we should not be handing out people's names and addresses like candy because you live in a homeowners association, then please vote yes. Vote green.
I recognize a member from Chippewa, Representative Van Binsbergen.
Thank you, Madam Speaker. I've been in this business in the housing business for 30 years. I tell you, I think this amendment is greatly misguided. I've not heard of that management companies are selling data of homeowners or that board members are handing out data of the people that live in facilities. And the answer to this is simple. We don't need another law to fix the problem. If that is happening, fire the management company. That's easy. Go hire another management company. I'm in the business. I've managed these kinds of properties before. I encourage members a no vote.
Further discussion to the amendment, Recognize a member from Anoka, Representative Scott.
I'm sorry, Madam Speaker. Would Representative Bahner yield to a question?
Representative Bahner will yield. Representative Scott.
Thank you, Madam Speaker. And the second time I spoke, I'm not sure everybody heard me, but I just want to reiterate that current law in 515B.3 allows me as a member of the homeowners association to ask the homeowner association to provide me the name and contact information of everyone in that association, and according to the law, current law, they have to provide it. So how does what Representative Gottfried is trying to do here, how do you square that with, okay, if we make this the law, the amendment to the amendment, I, as a member of the homeowners association, can get all that information myself and share it willy-nilly. This amendment doesn't address that. So I'm just wondering, Representative Bahner, how you square that, if she would yield to that question.
Representative Bahner.
I want to remind us that the section we're talking about with this amendment is the powers and duties of unit owners associations. I just want to remind everybody of that. This is the roles and responsibilities of someone who serves on a home ownership board, first of all. Second, it says in the amendment very clearly if they have an express business purpose. If it's in their bylaws and there's something where they have a purpose to be giving it out, then this doesn't contradict that. We're not asking anyone to do anything crazy here. We're saying, if you sit on the board, don't be handing out people's information without permission or without an expressed use for it, right? It's literally like data privacy 101. This isn't complicated. If you're in data privacy 101, and I'm sorry, oh, he is here. I was going to say, we have our resident expert in-house on data privacy sitting right over here. And Representative Elkins, but I just want to say, this is not complicated. This is best business practice in virtually any company, anywhere. It is best business practice in any organization. When I worked for Cisco System years ago, you couldn't just call in and get information on somebody's name and address from HR. You couldn't do that anywhere else. Why would you do it in a homeowners association? It's literally common sense. And while I would hope that most home ownership boards are already doing this, it's just a way to say to them, we're sending a signal that says, just as a reminder, it is best practice, because that's what all this is about, that you shouldn't be doing it. There's no penalty associated with this. There's no fine or fee. We're just reminding the members of the board that this is best practice, that you shouldn't be doing it. It's really quite simple.
Representative Scott. Further discussion? Representative, I recognize a member from Olmsted, Representative Quam.
Thank you, Madam Speaker. Best practices. Well, frankly, best practices is look for what could be unintended consequences be of any bill we pass. Are there any emergencies, any unforeseen things that could possibly come up? And this doesn't seem to pass that test because, frankly, there are frequently emergencies that happen. And oftentimes, that's not when the specific resident is available. And this doesn't have, it requires without express written permission. You're not going to be able to go, I have all 483 possible things that could ever happen written here, and then they sign for any of these possible activities. No. You can have, some HOAs have duplexes, quadplexes, a lot of different variations. And you might have one entity in a quadplex that's gone. And it might have work on everybody else's, but it is a weight-bearing portion of the roof on that one person that's gone. They can't give permission. And I just don't think you can come up with all the possible occasions. Now, if this had something in there, if there was personal structural danger or there was common some commonality where one of the members couldn't give express, that then there would be, a process. Intent is great, but I have seen so many times where we have passed with good intent to discover that caused real problems. And we as a legislature generally can't snap our fingers, have the governor call us in and take care of it. It's not like that. So that's why you look at, and if you're in a committee, you've got a lot of different people that have life experiences, different perspectives. You have a conversation, and you come up with a more inclusive, or you avoid unintended consequences. I'm not seeing that here, and so I don't think it's ready for prime time or a vote now. And like it's been brought up, sometimes it takes a year to get everything. Well, I don't think it would have taken more than a couple committee stops to have a conversation. You'd add maybe 3, 4 more sentences. You'd have the flexibility in an emergency to be able to respond correctly or reasonably. So good intent needs the process, and I'm going to vote no.
Further discussion to the amendment Representative Gottfried.
Well, thank you, Madam Speaker, and thank you for this vibrant discussion today. I do want to quick maybe dispel some misconceptions here. It feels like a lot of folks are forgetting about a couple of clauses of information here, or one specific phrase, express business purpose. Representative Quam, the example that you just brought up would be an express business purpose that this would be okay for. You also talked about the written permission to disclose, and I want to talk about what entity is actually affected by that. So in the case of this is starting on line 1.7 of this amendment to the amendment. In the case of an express business purpose, the association or property management company must retain an agreement from the third party or vendor that they shall not disclose or sell information of the unit owners or occupants without express written permission. The entity that at that point must not sell or disclose that information is the third party vendor. That's what it is. So if in your structural, there's a structural emergency that we have to deal with, the issue that you're talking about actually isn't an issue. Because what business does that, structural engineer coming in to your building to evaluate the structural integrity of your property, what business do they have with then disclosing that unit's or homeowners like actual private information, personal information, name and address to anybody else? They don't. They really don't. So I do think there was actually some confusion here as to what this bill was trying to do, and I hope that that kind of dispelled that right there. I am not going to withdraw the roll call. I'm just going to make that very, very clear. I'm not going to withdraw. I don't think it has to be a confrontational thing. I would be more than happy to work with you, Chair Nash, at some point next year with over the interim on some safe at home stuff. But again, this amendment is not about safe at home. This amendment affects homeowners under a homeowner association. So these are two different discussions that we're having, and I would love to be able to get to Representative Keeler's amendment that she's going to offer that actually talks about how this might be able to interact with the Safe at Home program. So as I said, I am still going to hold to the roll call that we have here. I think this has been a vibrant discussion, and I think we have one thing to do here. It is very simple. Do not sell private data that you do not have a reason to be selling. Do not disclose private data unless you have a reason to disclose it. It is as simple as that. And all the arguments that I have heard from my colleagues across the aisle is talking about anything but that. We're talking about process. We're talking about a program this doesn't even touch. The crux of this amendment is do not sell or disclose data you have no business selling or disclosing. Thank you, folks. It's been a fun discussion. Let's get to it.
The clerk will take the roll. The clerk will call the names of the members participating remotely.
Franzen. Franzen.
Okay.
Green.
Green, aye.
Green votes aye. McDonald.
Franzen votes no.
McDonald, no.
Comes back.
Turn it up.
Say it louder.
McDonald, no.
McDonald votes no. Momani Hiltsley.
Momani Hiltsley, aye.
Momani Hiltsley votes aye. Perez Vega.
Go ahead.
Perez Vega, aye.
Perez Vega votes aye. Franzen.
Franzen votes no.
Franzen votes no.
The clerk will close the roll. There being 67 ayes and 67 nays, the amendment to the amendment does not prevail. To the underlying amendment, the A5. Further discussion. Representative Meckland.
Thank you, Madam Speaker. Members on my side, I recommend a green vote on the A5 as is.
Further discussion to the amendment? Representative Bahner, to your amendment.
Thank you. I also appreciate my partner over there, Representative Meckland, and would encourage a green vote on the A5.
All those in favor say aye. Aye. Those opposed, nay. The motion prevails. There's an amendment at the desk. The clerk will report the amendment.
Kayla moves to amend Senate File Number 1750, the second unofficial engrossment. The amendment is coded A7.
I recognize the member from Clay, Representative Keeler, to your amendment.
Thank you, Madam Speaker. I just want to say a couple things based on the last conversation. One, I really think that the floor is a legit process. I think that what we do here matters. I think the conversations that we have and the amendments that we bring are real. I just want to make sure that I know that maybe some of you don't think that, but there are some legislators that really believe this is still a serious process in legislating. This did come to me with a constituent conversation. I also believe as elected officials, it's our job to genuinely listen to the concerns that our constituents have. Maybe they didn't call me in November or December to do this. They called me literally this week because they knew this bill was coming up. And I also want to just say, the group that I'm choosing to protect, like always, are the victims of violence. And so I know we have people that will stand up and say, oh, I'm a housing provider and this is bad for business. Well, I'm a survivor of violence, and so I'm gonna stand up and speak on our behalf. I think we have stories that are important to share. And so I had a constituent call me And as many of us do, we take time to listen to these stories, especially when they're kind of these one-off situations that didn't come in a huge group email that's copied and pasted. This was a genuine story. I have a constituent in my district that is terrified, like terrified. And I want us all to pause. We know what that feels like. I mean, maybe I'm the only one, but I believe that many of us know what it feels like to be terrified in our own home at the risk of violence. Like, the fact that we have to even convince ourselves of that is crazy. And so I understand that there is a process, and I believe that bringing amendments to the floor is a genuine option. And so that's what I'm trying to do. Safe at Home is a program that is designed to help people who live in fear for the safety, and it helps keep addresses confidential. What we know is high-level stalking starts with people finding out your address through mailers, through third-party vendors. What happened in my community is an individual had a business come in, take pictures of their entrances, share it with the other people in their homeowners association, and then was shared out to a third-party vendor that now is on a mailing list that everybody knows where this person lives. That's heartbreaking for me. And maybe I'm one of the only empaths here who actually tries to legislate and listen to the stories and the heartbreaks of my community members. But this is really, really devastating. And I believe it is more than just my constituent and one of Godfrey's constituents. I want to just remind us about domestic violence in Minnesota. At least 12 women died from intimate partner violence. 1 man died, 11 bystanders died. And these are all from people who were just trying to find a safe place to stay. So what I hope we don't do is get up and just really criticize the process. If you don't want to vote for it, don't vote for it. I'm going to call for a roll call.
A roll call has been requested. Seeing 15 hands, there will be a roll call. Representative Keeler.
Thank you. And so we're just trying to make sure that when the homeowners association ends up sharing out personalized information with your entrances, with your address, that there is a way that that person has teeth to go after the HOA. I also have to disclose, I'm a lifelong renter, so living in this world of HOA, it has nothing to do with me. It has everything to do with constituents that are in my district that are trying to make a change. So with that, Madam Speaker, I would ask for a yes vote and understand that sometimes people come to us in our constituencies and maybe they don't understand the arc of the session. Maybe we don't do the greatest job at telling everybody when to engage with us. I am really proud of my constituent who found it brave to call me, to share this, and to actually try to find a solution. Survivors deserve to be heard. Survivors deserve to be seen. And I believe a green vote stands up for survivors today. Thank you.
I recognize the member from Hennepin, Representative Bahner.
Thank you. And members, I think this one, and I acknowledge and I understand certain concerns about timing. But is there ever a really right time when folks have been harmed? And in this particular case, we're talking about individuals that are writing their legislator like they do to all of us, who are terrified. They're terrified because they've been the product of violence and their information is now exposed. And I just want to be thoughtful in that we talk a lot about unintended consequences. And in this particular situation, there are really high stakes, really high unintended consequences if someone participating in Safe at Home has their information leaked. If that ends up at a data broker site. I have been hearing from victims for years about how their attackers would stalk them across the internet. They would have to go into virtual hiding from being online. They would take great lengths to hide their identity and their location where they lived. They go to great expense to move to a new location so that they can feel safe at the end of the day, that they're not worried that the next knock on that door is the person who perpetrated the violence against them. And if you haven't heard from your folks, someone like in this situation who has been stalked across years by an ex-husband, an ex-boyfriend, whoever it is, that hasn't had to live in fear where they live, then I'd be happy to share some with you. But the reality is the consequences for not getting this right are pretty severe for an individual. Now imagine this happens to you. Imagine some of the folks in this room who are on the Safe at Home list, who had to move, they picked up their whole life, and they had to move to a new house, or a new apartment, or a new townhome, or a new condo, whatever. And then this information gets out. This isn't a small thing. Not only is your potential safety in jeopardy, and you now have to find a place to stay, including your children, if you have them at home, those little ones, which a lot of them do. And constituents who've talked to me have talked about having to move many times with their little ones just to keep their kids safe. When that happens, it's pretty extreme to have to pick up your entire life in a suitcase and try to move. And if you own this home, that's not a simple task. You don't just get up and decide you're going to move the next day. If we're talking about unintended consequences, the unintended consequences for getting this wrong are pretty high. And we certainly can continue to have this conversation, and we can certainly have this conversation about other housing forms and how we improve Safe at Home across the board. And I appreciate Representative Nash's bill earlier that made some really good innovations in that space, and I am really grateful for that bill. And I think we all wish that this situation had come up sooner and that it could have been included. But I think we understand unintended consequences, and we understand the impact on people's lives if we get this wrong. So I would invite folks to vote green on this and make sure that families are protected.
Further discussion to the amendment. I recognize the member from Carver, Representative Nash.
Thanks, Madam Speaker. And Representative Keeler, there we go. You and I have worked on stuff where I shared my own story. So please don't anybody think that I'm not interested in talking about domestic violence as the victim of domestic violence myself. Don't. And the bill that I worked on recently on the Safe at Home, very, very important. My constituent is enormously grateful. She told me that even after all these things, she's still, because of the department screw up, she's still afraid that she's going to be stalked, found, and killed by her domestic abuser. But we followed a process. We did. And Representative Keeler, and you're not going to be here next year, but would love to continue working with you, because you and I very much side by side on a lot of these issues. But process does matter, and in talking to a lot of the folks that would have to be impacted by this, they didn't hear anything. We didn't have a bill process, and bill processes matter. You know, as I was trying to move my bill to the Public Safety Committee, the Public Safety co-chairs had said, hey, we think we can get you in maybe, but if you change your penalty to a gross misdemeanor, we don't have to hear it. Those are things that happen as we move things through the committee process. It gives us more time to think through things. It gives us more time to make sure that the people who are universally impacted, not just those who are in the Safe at Home program, but those who have to live with the things that happen as a result of an amendment or a bill, it's worth making sure we put in the time to get the bill right for everybody. And members, I will, as I'd said before, I will continue to work on this issue because it's valuable. The Safe at Home program is valuable, and we should get things right. We should put in the extra time. We should put in meetings at 8 p.m. at night if we need to meet with everybody who's going to be impacted. But an idea that came forward very late in the game, I just don't see it. So I would urge a red vote.
I recognize the member from Ramsey, Representative Finke.
Thank you, Madam Speaker. I've been listening to the last, hour of debate on these two amendments, and I'm grateful for your work on Safe at Home, Representative Nash, and I'm grateful to that your constituent has had the experience of seeing change as a result from what they have lived through. And I just want to say I'm sorry to Representative Keeler's constituent whose experience was not of domestic violence and terror was not on a supportable timeline for the legislative process.
Further discussion to the amendment. Representative Keeler.
Thank you. Like I said, vote how you want on this. I do really think it's important that we uplift survivors and we listen to them. And I do want to say to my constituent, we genuinely tried. We're doing this over and over, and I appreciate when victims of violence stand up. I know how hard that is. I think many of us know how hard that is, and I am proud of your bravery. Please vote green.
The clerk will take the roll. The clerk will call the names of the members participating remotely.
Franzen.
Franson votes no.
Franzen votes no. Green.
Green votes aye.
Green votes aye. McDonald.
McDonald, no.
McDonald votes no. Momani Hillsley.
Momani Hillsley, aye.
Momani Hillsley votes aye. Perez Vega.
Go ahead.
Perez Vega votes aye.
Perez Vega votes aye.
The clerk will close the roll. There being 69 ayes and 65 nays, the amendment is passed. There's an amendment at the desk. The clerk will report the amendment.
O'Driscoll moves to amend Senate File Number 1750, the second unofficial engrossment. The amendment is coded A8.
I recognize the member from Stearns, Representative O'Driscoll, to your amendment.
Thank you, Madam Speaker and members. First, before I get to the amendment, I want to reach out to the author of the bill, Representative Bahner, and thank her for the opportunity to work with her on this bill. As many of you know, I have a professional background in many of Minnesota's regulated industries, including real estate, which is where the Senate File 1750 actually exists in 515B in the common interest community laws in the state of Minnesota. And when that bill came over last year from the Senate, it needed some work. There were some inconsistencies that are in there. And I, again, want to thank Representative Bahner for the opportunity to work with her, the team from with Co-Chair Koegel, and her team from Commerce, and our team from the Minnesota House. I am going to be in a very peculiar situation today. I support the bill and the work that's in there. There is one problem in this bill that we were not able to get resolved, and I believe it is a major stumbling block. And that is Section 14 of the bill, which is a preemption clause. Basically what it does is it takes away the authority from local communities to determine whether or not they would like to have a homeowners association govern property that the community will give special permission to be created in a CIC or common interest community. And that could be townhomes, could be condominiums, could be cooperatives, could be patio homes. What normally happens in a situation like this, members, is there's maybe a 60 or an 80 acre parcel of property, and instead of it being and I won't bore you with the details, but a single family detached that follows the normal zoning ordinances in a community, it allows for some exceptions on what's called a planned unit development. You can have narrower roads, you can put retention ponds, you can put private amenities in there. Those private amenities are things that sometimes attract people to purchase properties in a common interest community. Some may tell you later today that why should someone have double taxation, pay an association fee, as well as pay property taxes for similar amendments? And the answer is because they choose to do that. People get an opportunity to be able to choose to purchase what they want, where they want, and the kind of environment that they want to live in, and that's where common interest communities come into play. The other important thing that common interest communities provide is, as taxpayers in general, they help keep down your property taxes. And you may say, well, how does that happen? Because they're the first line of defense when a neighbor has a squabble with a neighbor about the dog running in the neighborhood, or you parked in front of my driveway, or your snow is on part of my sidewalk. All the things that city might get a call from with neighbor and neighbor. They deal with that internally in the common interest community through the homeowners association. And believe it or not, homeowners associations experience the same kinds of problems that others experience in the elected world, whether it be on a city council, the state legislature, whatever the case may be. And sometimes it's finding people who are interested and willing to run and make the commitment to do the hard work that it takes to establish good public policy, and in this case, establishing public policy in and for the owners of property in that common interest community. So I have asked the question when I sat down with Representative Bahner, and I said, there's a problem because this particular section doesn't actually do what you would hope it does. And I've been told that common interest communities can still be required. I understand that. I also understand that the developer can ask for a common interest community as well. There are many ways that property can be regulated, and because of that, it can create some clashes. The problem that you hear some others talk about today is that this is going to, this preemption provision is going to require communities to step aside and let the developer and not allow the city to require, for example, a monument sign that comes into a residential single-family home development, which would require a common interest community. And I support that. And so you're saying, well, why are you bringing this amendment forward? The reason I'm bringing the amendment forward is it's vague. It doesn't actually define what happens. And I am sick and tired of laws being challenged because we don't finish our work on here. And I was very clear early on that this provision needs to be resolved and needs to be worked on, and asked about it and said if it doesn't get resolved, I will be bringing it to the floor. And I'm a very transparent legislator, absolutely transparent legislator. Cards on the table, and I can be a little bit of a bulldog sometimes in a china shop. I get very passionate about things, and one of those things is doing our job right. And members, I was told, well, you know what, Representative O'Driscoll, if it's a problem, we'll just deal with it the first thing next year. And I'm appalled by that statement. Why are we putting a bill forward that we believe has problems, even by those who are the partners that were working on this, and not actually solving the problem here today by cleaning up that language, or taking this provision out, as my amendment does, and writing that language next year so that it's clear as to what's happening. I've also been told, and it's true, that there are a large number of people who are involved in home ownership who are covered by homeowners associations through Chapter 515B. So I scratch my head and I say, why would we go and pass a law with foggy preemption language in here when we could fix this instead of making life miserable for future creations of common interest communities under 515B? I have professionally been involved in the real estate industry in the state of Minnesota since April 23rd, 1983. And why do I share that day with you? Because it was the day that I turned 19. I've had a real estate license in the state of Minnesota since I was 18 years old. That's how I funded college, professionally trained. And it's been my honor to be able to share my experiences and my understanding and technical experience over the years with this legislature. And I am head down, working hard till we go sine die to make sure that we have good public policy. And since 515B is within the realm of the Commerce Committee, I can't go home in good conscience and say, we passed a pretty good bill, a bill that does a lot of good things, when we know there are problems with this preemption section. And your local units of government have problem with it. I've heard from association groups, they have problems with this. We actually had really good peace in the valley on a lot of these things until we started getting the tent flaps popping up. Members, I encourage you to vote with me to remove Section 14, which is the preemption language, and let's do it correctly. For all the people who are going to be homeowners that I've heard people talk about on this floor today that we want to protect. If you are in wanting to protect people, then you are certainly going to support the O'Driscoll Amendment today and vote yes. I'm also smart enough to know, having been around here, that the speech that I just gave will bring a few other people speaking to this issue. We will have a vote. The speaker will say the amendment does not prevail, and you're going to have a bill that has problems in it because we didn't take the time to finish out the last steps on this. And again, I'm not coming Johnny come lately, as the saying goes. I brought this up early on. And I went to Representative Bahner and said, I know this has been sitting here for almost a year in the House since the Senate sent it over. Let's make it workable. Let's make it functional. I also want to let you know that I support the bill and would be voting yes today on the bill, and will vote yes on the bill today if Section 14, the preemption, is taken out and we do our homework right and we pass that provision so it actually makes sense. And we don't add to confusion that people have been talking about and on the floor and in committee on this bill. So members, I encourage a yes vote on the A8 amendment to provide clarity for people. And if we feel we need to have additional work on this, let's do it in committee, let's get it right, let's bring stakeholders and work on that last step before we put this into law and create more confusion and the full Attorney Employment Act. Thank you.
Further discussion to the amendment. I recognize the member from Hennepin, Representative Bahner.
Thank you. You know, I just want to bring one point to light too. We talk a lot about process, and I want to just say that there were a number of issues that came forward with this early on when we came to the language that's sitting before you. And this language has been sitting in the bill through many committee stops. I'm sorry, I forgot how many at this point. They all have blurred together. And they've spanned multiple years. When this provision was brought forward in the Commerce Committee and discussed, it passed on a vote of 11-1. 11-1. And so it has been very carefully looked at and discussed over time. We made the agreement on this specific language well over a year and a half ago, and it has sat for that time. And then the other night, after all of the work had been done, and we buttoned up the bill and we buttoned up the last items, and for anybody who's wondering, if you will ask anybody in the process whether they agreed with the bill or didn't agree with the bill about whether I have been a fair dealer throughout this process, I think they will all tell you that I have always been open and willing to conversation on any aspect of this bill. And I have the receipts. I have hundreds of lines of change items from random folks across Minnesota, homeowners, board members, folks from the bar, folks from CAI and MCAA and all of the letters who have weighed in on this bill. And in all that time, no one seemed to have a concern with it until 2 days ago. 2 days ago, someone from the counties who, let's be honest, didn't do their homework, came and started getting folks excited. And when that happened, we started digging deeper and going back into it, because I'll be honest, it had been a year and a half that this language had been out there and negotiated, so I had to go back and dig into my notes and look through and find out what the background on this particular issue was. But I wanted to say that in that process, we came through and said, I came back to them and I shared with them, because the primary concern they had was about the maintenance of shared elements. So let's keep the goal in mind. Everybody, here's the goal. The goal was making sure that HOAs, particularly those that exist today, that have shared elements, whether that's a septic system, a stormwater pond, whatever it is, that they would continue to be maintained properly. Now, under this bill, I want to be very clear with you, this bill has nothing to do with any existing agreements with an HOA. It doesn't compromise any existing agreements about maintaining shared infrastructure. It literally does none of that. It, quite frankly, it also has nothing to do with forbidding builders to require an HOA if that is the best outlet to maintain shared assets. It also doesn't stop them from building a product that buyers would want to buy. They're certainly welcome to do that. They're welcome to have shared elements in which that would be required. Developers can ask for one if that's the best instrument to do it. Builders can ask for that if that's the best instrument to do it. But there's also many tools in the toolbox that can be used specifically for maintaining shared assets. And I'll be upfront with you, so my family is only recently city dwellers, right? Part of my family came off the farm, part of them came from southern Minnesota, some are from greater Minnesota, up by Nisswa and Lake City and Brainerd and Pierce. And my family had a situation where we had 3 properties on a lake. All 3 brothers got a piece of property. Because we had those 3, we all had a septic system that we shared. When everybody decided that they wanted indoor plumbing, because these days you don't build anything without a septic system if you don't have access to get rid of that sewage, because people really like having indoor plumbing. So there's nothing in here that stops you from creating those systems in which you would. This, even if you take it off of this amendment, or you take the O'Driscoll amendment, or you leave it on, either way, it doesn't do any of those things, right? It doesn't stop you from building it. It doesn't stop you from maintaining it. It doesn't stop you from agreements to maintain it. It doesn't stop you from having accounts to be able to maintain it. It doesn't do any of those things. The only thing that this provision does, very specifically, is it says that an HOA may not condition approval of a residential building permit or conditional use permit on the development that would necessitate the creation of an HOA. And for the most part, most folks have agreed that what that means is not, we're not talking about infrastructure, right? Because you can't build a building development without infrastructure. If you don't have the infrastructure, nobody's going to buy your building. They're not going to buy your house, right? If you don't have any way to have indoor plumbing in greater Minnesota because the footprint means that you have to have a shared septic system, there is nobody who's moving in that doesn't have indoor plumbing. You have to have it. This doesn't prevent you from having an HOA to maintain it. It just says that a city, a county, a municipality cannot say to, hey, builder, you want to build some fancy clubhouse, you want to put up a giant monument on the entrance to your development, you want to build a pickleball court. The city can't tell you or the developer that they have to require a pickleball court. It can't tell you have to require a park. Now, if in that community people are rabid pickleball enthusiasts and they want pickleball courts and that's the way to sell their product, they can certainly do that. And if the homeowners choose, operative word choose, if they choose those amenities and they're willing to pay for them, this doesn't prevent them from doing that. It literally says City, county, you can't require somebody to build a pickleball court. You can't require them to build whatever else. And if your city is fully built out, for many of you who actually have that situation, this piece of the bill will probably never even bother you. You won't even see it. You won't know anything about it. Because all of those homes that have existing HOAs and maintenance agreements and all of that remain intact. They don't go anywhere. They're still there. They still have to maintain it. And depending on the nature of that particular item, such as a septic system, and by the way, there are other mechanisms to provide for the maintenance on that septic system that don't involve an HOA. You can have what's called a shared septic maintenance agreement, an SSMA. Those sit on your deed. They make it clear that you have the responsibility for maintaining that shared infrastructure, and it also makes sure that there's access to that infrastructure so that people can maintain it, that they can service it, they can check on it. And in the case of a shared septic system, which is the example that came up at the 11th hour here, quite frankly, there is no chance that somebody cannot maintain a septic system. If you have one, which I'm sure some of our Greater Minnesota members probably do, it's got to be maintained. It's got to be cleaned. You need to pump it out. You need to make sure it's working properly, because if it's not, it ain't great. So I want to be very crystal clear that this amendment doesn't forbid you from having all of those things. It just says that cities cannot condition the approval of a development on a shared common element, like a pickleball court or a park or a clubhouse, when they're approving these building developments. That is it. It's very simple. It's very straightforward. I would urge folks to vote green.
I recognize a member from Sherburne, Representative Meckland.
Thank you, Madam Speaker. There has been a lot of different conversations on this, but one of the things that keeps coming up is the shared septic and the shared well. But under 515B, which my colleague Driscoll has mentioned, it is very clear that cluster developments in rural areas under well and septic would have to be, by definition, be put into an HOA. The intent behind this is simply that the local municipality, the governing body, cannot require an amenity that forces an HOA for the developer that wants to build a development without an HOA. They don't want all the amenities. They want plain Jane, simple, affordable properties. And we're finding more and more that they are forcing these into every area throughout where we're pulling permits. In meeting with all the builders in Minnesota, I have not yet found one that is against this provision. And furthermore, when this Chapter 14 or Section 14 was heard as a standalone bill in local gov, and in that, the League of Minnesota Cities was neutral on it. So that is where all this is at. And I would like to, Madam Speaker, request a roll call.
Roll call has been requested. Seeing 15 hands, there will be a roll call. Representative Meckland.
Thank you, Madam Speaker. And with that, members, I encourage a no vote.
Further discussion to the amendment. I recognize the member from Hennepin, Representative Acomb.
Thank you, Madam Speaker. And I rise in support of the O'Driscoll amendment. I sat on local gov and elections when this provision came forward, and I shared my concerns then in terms of stormwater management. I live in a city that has 400 stormwater ponds, and if a city cannot require that the development that is causing the need for a stormwater pond, if they can't require that maintenance through an HOA, then those costs and that maintenance is going to fall on the rest of the residents of the city. And so in a city like mine, where there's currently 400, that's a big cost. And so I have concerns not about pickleball courts. I don't think that that's where I agree with Representative O'Driscoll. This needs more work, because I agree that pickleball courts and clubhouses are not something that should be requiring an HOA. I think when you have a stormwater pond that is needed and is caused by a development, that should be required, just as was talked about in terms of a septic system. We live in the land of 10,000 lakes, and as we continue to grow and develop, the outer ring suburbs, as they are building more homes, are going to continue to need to develop more infrastructure for stormwater. And if there isn't a method or an opportunity to get the community that is causing that, those homes that are causing the need for that stormwater to pay for the maintenance, then that falls on the rest of the taxpayers, and I don't think that that is a fair way to do it. My cities have reached out to me about this provision, and I encourage people to vote green on the O'Driscoll amendment. Thank you, Madam Speaker.
Further discussion to the amendment. I recognize Representative Bahner.
So I just want to circle back for a brief moment. Again, we talked about maintenance. I just want to make sure that folks are aware that on line 5 or 51.22 of the bill under exceptions, it specifically has nothing in this section prohibits a local government from requiring the maintenance or insurance of common elements. I want to be very clear about that part in case anybody hasn't read it already. It's covered. I also want to make sure that we say that it also provides, as under on 51.25, that a project applicant, it also, nothing in the section prohibits the project applicant from providing an easement to any public infrastructure as well. We also had this conversation about falling on the back of all the taxpayers. First of all, many of these structures exist today. When they do exist, they generally do require some sort of a maintenance tool. Whether it's an SSMA, that shared septic maintenance agreement, whether it's an HOA or something else, that's just good business practice. Those things already exist. This bill doesn't forbid that. You can still do that. And in fact, I highly recommend it, by the way, just to be clear, because those bills do eventually come due, and just like shared dock access or a shared road or whatever it is, if it needs maintenance, at some point, if it's your responsibility under the agreement when you purchased your home, you're going to want to make sure that you have funds to cover that, so you don't have to do that out of pocket. Also, when we talked about falling on taxpayers, let's also be clear that, let's just say hypothetically, that a city decide, the agreement between a builder and a city is that they own a piece of public infrastructure. If they do, there's also this sense that you also have the ability to levy assessments against individual homeowners for very specific things. So a couple of years ago, we got an assessment on our home because they were going to replace the street in front of my house. They were going to redo the curbs. And the city came to us and they handed us a thing, which they do this literally every day. And they said, you can either pay this amount, X amount up front, or you can spread it out on your property taxes over so many years to make it more affordable. Now, fortunately, we were in the cash position to be able to just pay for it up front. But a lot of people choose to put it out over time so they don't have a big bill that comes due. And it is assessed specifically to the people who are impacted by that road and that curb. Not every taxpayer in the city paid that assessment. I did. My family did. The same is true of a stormwater pond or other piece of public infrastructure that is there for the express purpose of a certain number of houses. So if there are 5 houses around a stormwater pond, there is no reason that you would put that on the taxpayers of the entire city, that would be crazy pants. You would assess the people around the infrastructure. So let's not be talking about sending this to everybody. But in most cases, you are going to have an HOA if you have shared infrastructure like this. Or you're going to have an agreement, which is another tool that doesn't require an HOA, and those have been in existence for decades. They ride on the deed of your house that requires you to maintain infrastructure. If there's a septic tank on my property, it's my responsibility. It's not somebody else's. It's not the city's. It's not the county's. It's nobody's responsibility except for the homeowner. This bill doesn't change any of that equation, just to be crystal clear. I also want to make clear that the Minnesota Common Interest Owners, Minnesota Common Interest Ownership Act, which was established in 1994, also grants boards authority over assessments, insurance, and management of cluster developments in rural areas, including things like wells and septics that could be classified as common property and would require an HOA. It's literally already in the statute. So if one of these is required as the course of building it, there are already mechanisms in place to ensure that they are properly maintained and that they are, in fact, levied to the people who actually live there. And I also want to end with this. This bill is supported by folks like the Twin Cities Habitat for Humanity and Housing First. These stakeholders have been with us during the entire process. They understand why this amendment or why this provision exists in the bill. They get it. There is nothing in this bill, I'm going to repeat it again for the folks in the back, that will not allow a city to make sure that privately owned infrastructure is maintained by the people who own it. Nothing in this bill does that. And with that, I want to correct myself and thank you, Representative Igo, or Chair Igo. I want to encourage folks to vote red on this particular amendment. A roll call has been requested, but again, I'm going to reiterate, I encourage you to vote red.
Representative O'Driscoll, to your amendment.
Thank you, members, for the discussion. Thank you, Madam Speaker. I want to correct a couple things that Representative Bahner said. I believe she misspoke when she said it was the Commerce Committee that voted 11-1. I think she meant to say the Government Operations Committee has an 11-1 vote on it. And I encouraged when we came through the Commerce Committee that we could support this, because I had, in good faith, worked with Representative Bahner, and as we were going through the bill, when she was saying no one raised the issue, I want to reiterate the fact that I did raise that this was an issue and that we were going to have this conversation today, which are about ready to complete and start voting on if we didn't get this resolved, because it's an important provision. And unfortunately, we never got to that point. And members, I would encourage you to vote green on this. And don't put out the door something that we took over, as Representative Bahner said, a number of years. And I was very, again, happy to, at my initiation as the co-chair of Commerce, go last year to educate our committee, spending about an hour and 20 minutes talking about how CICs work, walking through the things, answering members' questions. Received a lot of accolades and appreciations from some of the groups that Representative Bahner was talking about, and educating my counterparts on the committee who has jurisdiction on this, and also bringing forward this issue today. Again, I am going to encourage you to vote yes. And I do thank Representative Mecklin for the roll call, because I think it's actually going to be closer than I thought it was going to be. And so it's going to be kind of interesting to see how this comes down. Thank you, Madam Speaker. And members, vote yes.
The clerk will take the roll. The clerk will call the names of the members participating remotely.
Franzen.
One more time. Franson votes no.
Franzen votes no. Green.
Green votes aye.
Green votes aye. McDonald. McDonald. Momani Hiltsley.
Momani Hiltsley, aye.
Momani Hiltsley votes aye. Perez Vega.
Go ahead.
Perez Vega, no.
Perez Vega, no. Myers. McDonald.
McDonald, no.
McDonald votes no. Myers. Myers.
Go ahead. Myers votes aye.
Final bill.
No, it's the amendment. Myers votes aye.
Myers votes aye.
Myers votes aye.
The clerk will close the roll. There being 47 ayes and 86 nays, the amendment is not adopted. There are no further amendments at the desk. The clerk will give the bill its third reading as amended.
Third reading, Senate File Number 1750, as amended.
Third reading. Discussion to the bill. I recognize the member from Hennepin, Representative Katiza-Wattoon.
Thank you, Madam Speaker. Members, I rise in support of this bill. I appreciate, I just want to put out right away that I so appreciate the bipartisan effort that has gone into this process. Representative Bahner, the senators in the other body, those who have worked on this and contributed to this. This is something that I have heard from my constituents about over and over and over again for the last 8 years, and it has been a labor of love, certainly on your part, and it has not always been easy. I think the discussion today really kind of shows that there are still issues that we're going to have to work through going forward, but this package has been decades in the making, and I support the many provisions that are included, and know that this is not the end-all be-all of us dealing with the homeowners associations and common interest communities, but on behalf of my constituents who reside in the numerous homeowners associations within Eden Prairie, I will be voting green today.
Further discussion to the bill? I recognize the member from Hennepin, Representative Howard.
Thank you, Madam Speaker. And I, too, first want to thank all the legislators that have worked for years on this, but especially Representative Bahner. I remember having a conversation with Representative Bahner, I think in 2022 was the first time we talked about this, and worked together in 2023 to pass the working group of which you led. And ever since then, I mean, this has been such a challenging issue with so many thorny sides and issues, and getting into the weeds and different stakeholders, and just your earnestness in always keeping the main goal in mind, which is the rights of Minnesota homeowners at the center of this hard work, and to reach this bill, the consensus around this, and I know not everyone's thrilled with every last piece of it, but the consensus on this is really a feat, and it's going to make a huge difference. You know, members, HOAs are an entity that they essentially have, you know, governmental powers, you know, to fine, to levy fees, to police behaviors and freedoms, and even to foreclose on someone. You know, these are huge powers that can have severe consequences on the quality of life for individuals and families. And, you know, we as the state, we grant HOAs that power. And as folks have mentioned, it's been years and years since we've taken a hard look at the ways that we interrogate how those powers are being used. And as chair of the Housing Committee, I have fielded dozens, if not hundreds, of emails and calls with horror stories about ways that HOAs have abused these powers and in very unjust ways. And we know that most HOAs are operating very well and in the best interests of their constituents. And the balance being struck here is to make sure that those HOAs that are operating well can continue to do so, but that we're honoring the rights and freedoms of Minnesotans. And the ways this is doing that, limiting foreclosure powers, limiting those unjust fees, removing conflicts of interest, creating more ability for homeowners to navigate disputes and more ability to participate in these processes. All of these vital reforms will protect foundational rights and make housing more affordable for the million-plus Minnesotans who live in HOAs. It is an excellent, excellent bill. After years and years of hard work, and I look forward to seeing a lot of green votes on the board. Thank you.
I recognize a member from Itasca, Representative Igo.
Thank you, Madam Speaker. Just also want to give some credit where credit is due to Representative Bahner and Representative Meckland. These two have been working so hard on this issue and bringing it to light. And I think it really represents one of the best parts about this tie that we have in the House is that this really good bipartisan work was able to happen. So from our first couple hearings in the Housing Committee hearing about this stuff, the task force work that they did, it was just incredible to have this bill in front of us today that's really going to clean up quasi-government, for lack of a better term. Is just a really good step forward by this chamber for the state of Minnesota. I've been saying to some of my colleagues in preparation for this bill, you know, it's almost 1.7 million Minnesotans live in an HOA. So every single one of us has constituents that have been dealing with this, and for the most part, HOAs are great, and we're not saying in this chamber today that they're bad. But it's time that we clean this stuff up and get it back on track so that everyone, no matter where you live, has a good semblance of peace of mind that the rules and regulations around them are manageable and they can have a good quality of life. So I encourage a yes vote on the bill today, and just again, hat tip to Representative Bahner and Representative Meckland for their hard work. This is a good bill.
Further discussion to the bill. I recognize the member, Representative Meckland.
Thank you, Madam Speaker. That'd be from Sherburne County, by the way. Sorry. To Kristen Bahner, or Representative Bahner, this has been, what, a 2.5-ish year thing now? When this legislative work group was initially started, I did not know about it, and I think it was Senator Lucero that informed me of it. And I immediately called Speaker Demuth that evening and begged to get on it. So this has been quite a ride. There is a lot of very painful stories we've heard through this whole process of people that are being harmed. I will give Representative Bahner a tremendous amount of credit. All the emails, and there's thousands of them, and man, she was back on these things and copying all of us on this, and she did an amazing job. And this was a very collaborative effort between Senator Lucero, Representative Bahner, and myself. Vote green. Thank you.
Any further discussion? To the bill author, Representative Bahner.
I want to say thank you to a lot of folks, because this has been sort of what feels like an epic, right? I want to thank, obviously, my bipartisan authors in the Senate, Senator Lucero and Senator Pah, for their diligence. Of course, my partner, Representative Meckland, who did a tremendous amount of work and input, to Chairs Howard and Igo, who were incredibly supportive, as well as Chairs Koegel and O'Driscoll, who helped us get down to brass tacks on this bill and get it done. and I'm thankful for all of that. I also want to thank some very specific contributors, our stakeholders in support and opposition to the bill. By having this conversation, we've come a long way from where this bill started. In fact, most of the time when I get emails today, they are about the bill when it was introduced. But the bill today is a very, very different bill. It balances flexibility, and it balances the duties of homeowner boards and property managers and homeowners to set better expectations. But in doing so and helping us get to that place, we couldn't do all of that without the very incredible dedication of some really tremendous people. And if you're listening, Mary Davis, I owe you a really good dinner for all of the things you've had to do to get this bill in shape. To Molly and Sam O'Neill and Benji and our GOP staff, Ben and so forth, to my LA Chris and intern Caden, who have also been in the path all the time, running interference and making sure things got done. But I also want to thank some very profound contributors, some folks who provided a ton of expert advice along the way. And yes, Ron, I mean you. From legal aid to the Home Ownership Center, to the Housing Justice Center, to Twin Cities Habitat for Humanity, Housing First, the AARP, MCAA, CAI, all of these folks provided an incredible amount. And a plethora, by the way, of attorneys, board members, and private homeowners all over Minnesota. If you wrote to me, I read your email, and you might have ended up as a change request in our change log. So I listened carefully for any item or suggestion that could improve the bill and listened to people from various viewpoints across the spectrum who really, really varied. It's been an epic journey, and I am so deeply grateful for all who made this bill better and stronger. The Homeowners Bill of Rights creates a solid foundation for transparency, best practices, but above all, consumer protections. It creates common sense rules of the road to better define roles and responsibilities and define expectations for homeowners, boards, and property managers to set them up for success. And while most folks hadn't realized, it was very important to the authors of this bill, and nothing went in this bill without the approval of all 4 bipartisan authors. What was always at the forethought of our mind was how we make sure that the voices of homeowners were represented, that we rebalance those power structures that have become very out of whack over the last 32 years. And it is our hope that by putting this bill in perspective and talking about best practices and transparency and all of the things that are best for these volunteer boards to follow, that we've set expectations, we've made clear their roles and responsibilities in language they can understand, that they don't need to pay an attorney $250 an hour for, that they can actually read the statute and understand what they need to do to avoid conflict, to be good neighbors, and to care for one another. Because I know that there is no one in this chamber who wants any more nightmare stories about someone losing their home for a $56 fine. No one wants to hear about the woman who was disabled and had to buy a riding lawnmower only to have her HOA tell her that after she took great pains to make sure it matched her house, that if she didn't tear it down, even though she followed all building codes, because they wouldn't answer her about getting that project done, and then after she made the expense of tearing it down, they handed her a proposal for a $50,000 addition to her house to house the riding lawnmower. Now, these are egregious examples, right? If you don't like people telling you whether you can drive or park your truck as a small business owner in your own driveway, this bill is for you. If you don't like somebody telling you whether or not you can proudly fly the American flag over your house, this bill is for you. If you think that you have had a situation in which the conflict between neighbors has escalated out of control, along with the attorney's fees for crazy things like not putting your garbage cans away at night, this bill is for you. If you're a legislator in this chamber right now and you have combed through all of the emails about these issues that are heartbreaking, knowing that we could never do anything to help, this bill is for you. But most importantly, this bill is for every homeowner in Minnesota who worked tirelessly to provide their suggestions and their feedback, to show up at the listening sessions, to tell us all of their stories, and for us to come to a path where we could rebalance all of that power. This bill is about making sure that your home is affordable, that you can stay in your home and you don't get foreclosed for silly reasons. It's about making sure that you have good, responsible relationships with your neighbors. That's what this bill is at its heart. And I am really grateful for all of the folks who helped get us here today. And I want to say a special shout out to Jen, my constituent. When I started in the legislature, she brought to me this incredible saga of what she had been through with her homeowners association. And at the time, I knew nothing about it. And I'll be upfront with you, like most of you in this room, we treated it like a hot potato. Nobody wanted to dive into the depths of that despair. But I'm grateful to her for bringing it forward. I'm grateful that in the end, it has made me the unofficial de facto queen of the HOAs, a distinction that I am now proud of. But really, today is a victory for homeowners. And I want to appreciate all of the hard work that got us here and all of the people who got us here, and above all, to acknowledge those individual Minnesotans who live in HOAs across this state. This one is truly, truly for you. Vote green.
The clerk will take the roll. The clerk will call the names of the members participating remotely.
Franzen.
Franzen votes yes.
Franzen votes aye. Green.
Green votes yes.
Green votes aye. McDonald.
McDonald, aye.
McDonald votes aye. Momani Hiltsley.
Momani Hiltsley, aye.
Momani Hiltsley votes aye. Myers.
Myers votes nay.
Myers votes no. Perez Vega.
Go ahead.
Perez Vega, yes.
Perez Vega votes aye.
The clerk will close the roll. There being 100 ayes and 34 nays, the bill is passed as amended and its title is agreed to. Motions and resolutions. There are copies of the non-controversial motions at the House desk and online. If there is no objection, we will take action on these motions first. Hearing no objection, the motions prevail.
Reimer moves that House File Number 4779 be returned to its author.
Recognize a member from Chisago, Representative Reimer.
Thank you, Madam Chair. That is my motion.
Last thing up there.
It's a sales tax exemption for Chisago County. Chisago County did not have any specific projects specified. So, thank you.
All those in favor say aye. Those opposed, nay. Motion prevails. There's a motion at the desk. The clerk will report the motion.
Niska moves that the rules of the House be so far suspended so that House File Number 3819 be recalled from the Committee on Children and Families, Finance and Policy, be given its second and third readings, and be placed upon its final passage.
I recognize the member from Anoka, Representative Niska, to your motion.
Thank you, Madam Speaker and members. This week we were reminded again about the multi-billion-dollar fraud scandal racking our state when 22 child care facilities were raided, and it's important that we as the governor said from this rostrum, send him bills that he can sign to fix fraud. House File 3819 is urgently needed in order to fix the fraud in the CCAP program, and I will defer to Representative West to further discuss the bill. But first, Madam Speaker, I request a roll call.
Roll call has been requested. Seeing 15 hands, there will be a roll call. I recognize the member from Anoka, Representative West.
Thank you, Madam Speaker. So we all know childcare is outrageously expensive. Trust me, I know. I pay around $900 a week for my 2 kids. It costs around $20,000 a year for the average infant in a center. It costs taxpayers around $500 million a year in the CCAP program. And despite all this money, providers still close. There's no access, and it's ridiculously expensive. Why? Well, there are a lot of reasons, but one thing that's been made abundantly clear is that fraud is an epidemic in our assistance programs in Minnesota, and CCAP is among them, to the tune of maybe $100 million from what we have heard. Minnesota's become a fraud tourist destination. Literally, people come here because our programs are so generous. We just had 20 centers-ish raided by the FBI investigating fraud. So even the FBI come here for our fraud tourism. In fact, the center that has more money yearly from the CCAP program, that gets more than everyone else, is also owned by the 79th person to be charged in the Feeding Our Future fraud scandal. They got over $3 million in a year of CCAP. And you know fraud is real bad. It's real bad because just after the raids were announced that the federal government and the FBI are getting after fraud in the child care program in Minnesota, Governor Walz immediately took to the internet to highlight his role. And he certainly does have a role. And when the charges come out from these raids, we're going to be floored yet again with the absolute insane amount of fraud in this state. We're at billions of dollars with the Feeding Our Future program. Who knows what we're going to be at with the $500 million in the program, just CCAP alone. So how did it get out of hand here? Well, we've been warned for years by the Office of Legislative Auditor, by whistleblowers, that we have these massive vulnerabilities in our system all the way back in 2018. And little things have been done, which at least something's been done. But these raids just happened. So clearly not
enough has been done to deal with this. And in the Children and Families Committee, we heard a lot from the department, and we learned some interesting things. For example, while there is licensing visits every year, they said, well, the licensing visit isn't a program integrity visit. It's not their job to look for fraud. So when they show up to a center that should have 100 kids and there's 3, well, the fraud worksheet that is part of their inspection, the fraud worksheet is optional. It's optional. And you know, why is it considered going above and beyond the call of duty for an inspector to look for fraud? That's just wrong. So we have this system where fraud is staring us in the face. We've known about it for years, but haven't done enough. Minnesota government programs, we have all sorts of them. The Feeding Our Future stuff, the Promise Act, I mean, it's a all-you-can-steal buffet. And we just keep getting more and more people coming here just to take advantage. So House File 3819 closes these massive vulnerabilities in the program. It reinstates the penalty of perjury when you submit your CCAP attendance records. Because, well, you should be able to attest that your attendance records you're getting paid for are accurate. And that used to be, in 2013, before 2013, we did have that perjury penalty. It also mandates that electronic attendance tracking goes into effect. Now, we're already doing this, but there is no timeline of when this is going to be done. Well, we're starting it in June. And we don't know how long it'll take. They can't give a timeline. And we need that if we are going to root out fraud in this system. It also requires unannounced in-person inspections. So right now, the most likely situation is a licensor notices as a fraud situation when they visit a child care center. They're not required to report it, but that's how it rises to the effect. And in this bill, we also require them to consult the attendance sheets because they're not required to even look at attendance records. And with the real-time attendance tracking, they can now check and verify whether the attendance records match who's in the room, who are the taxpayers paying for. And for centers that get over $500,000 of CCAP every year, $500,000 of taxpayer dollars, they are required to have camera monitoring where the kids sign in at their entrances and exits. Because we need to be able to check that their records reflect what they're getting $500,000 for from the Minnesota taxpayers. Because without monitoring, how are you supposed to know that when they claim they check Johnny in, is that really Johnny? And also, it allows for remote check-in. So the department, if they're suspicious, they can request the data from a center and look, see, does it match? We have the electronic attendance here. Are we seeing that in real life, in real time? Because right now, sure, we can suspect fraud, sure, we can start to investigate it, but it is so hard to actually root it out. House File 3819 is absolutely necessary so that when we spend $500 million on childcare, it goes to the people who really need it and to the providers who need it and not to fraudsters. Minnesota taxpayers are tired of being an ATM for fraud. This has to end. So I urge members to vote yes on this urgency motion to take up House File 3819 because while we're discovering fraud with our current system, I guarantee you we're not going to get at all of it. There's going to be so much left, and we owe it to Minnesotans that when we take an enormous amount of tax dollars from them, that we should use it well, use it wisely, and take care of it as if it was our money. Because after all, it's the people of Minnesota's money. And it's an absolute travesty that we've lost billions to fraud in this state. So members, please vote green.
Discussion to the motion. I recognize a member from Hennepin, Representative Katiza-Wattoon.
Thank you, Madam Speaker. Members, I'm going to ask you guys to vote no against this motion. This bill is not ready for prime time. Fraud in any shape or form is a problem, and we are taking urgent action, and we have been since my co-chair and the speaker were on the early childhood subcommittee with me in 2019 and 2020. And Chair Pinto was leading us in that committee. We took urgent bipartisan action that session with the Republicans in control in the Senate, and Governor Walz signed those bills into law. The numbers that my co-chair quoted, up to $100 million in child care assistance fraud, are back from almost a decade ago. And members, it's really important that you know that only 6% of that fraud was ever realized, actualized, and convicted. We can talk about big numbers all we want. That doesn't make them real. And we really have to consider that the conversation that we had just a couple weeks ago on the House floor when Representative West brought an urgency for his camera mandate. Many of those provisions are packaged into this bill as well. So all of the things that we talked about when we talk about child sexual abuse material are also issues with this bill. I think that there is a valid conversation that we can have about exterior surveillance and how that could assist the department in doing attendance checks and verification. But the language of this bill is not how we would want to go ahead with that. The one thing that I do agree with in this bill is the electronic attendance monitoring. And Co-Chair West did speak to the fact that this is already happening. The department will be rolling out electronic attendance monitoring statewide over the next 6 to, what month is it? It's April, May, but before January 1st. I'm losing track of the days here. We've only got 2 weeks left, right? But I think that when we look at what happened earlier this week with the federal government and some of these child care raids, it is important for Minnesotans to know that ICE was with the FBI on these raids. And what happened in December, what kicked off Operation Metro Surge, was that the president accused Somali child care providers of not taking care of kids, of inventing children, specifically singling out members of our community. And, to the extent that our law enforcement participated in the raids this week, that our departments have cooperated with the feds and given all the information that they have to give, we are doing everything that we can to root out fraud and prevent it before it starts. But this bill, in addition to the problematic provisions within, it also doesn't have a Senate companion, and it's just not ready for prime time. So members, I would ask you to vote against this urgency for so many reasons, including the concerns about child sexual abuse material, the concerns about cost, the fact that it is, it's just not a good bill. So vote red.
I recognize the member from Hennepin, Representative Robbins.
Thank you, Madam Speaker. Thank you, Chair West, for bringing this urgency. This is urgent. Our Fraud Prevention Committee did a hearing on child care fraud on Tuesday. If you haven't had time to watch it, you should maybe check it out. These are essential steps to prevent fraud in child care. We used to have the requirement that people would sign under penalty of perjury that their attendance records were accurate. That got taken out. And we need to put it back in because the failure to provide adequate attendance records is driving this fraud. And to the point that was just raised, that the $100 million is not accurate and that only 5 to 6 million was proven, I want to take you back to that situation. And we had great testimony on that in committee this week. So back in sort of the 2017, 2019 period, they were doing actual criminal investigations of fraud in DHS. And they had a criminal investigation unit that was conducting searches, conducting surveillance. They got warrants and seized cell phones, computers, and they were building these criminal cases. And 2 of them went to trial, and the people were convicted. And they were just in the beginning of building all these cases and getting all this evidence. And what happened was the head of the criminal investigation unit wrote, and because there was a lot of press around this, the legislature in 2018 directed the OLA to do a report on CCAP fraud. And that process was going on in the summer and fall of 2018. And the head of the criminal investigation unit wrote a memo outlining all the things they were finding and all the red flags they saw in fraud. And the then Inspector General in DHS tried to stop the head of the criminal investigation unit from sending that email to the OLA. And the head of the criminal investigation unit pointed out rightfully that that is a crime because they are mandated to report to the OLA. And eventually, after a lot of back and forth, the memo was sent to the OLA. And that is where the number 100 million comes from. Because based on their evidence they had found to date, they felt confident that 100 million back then was a safe estimate of the fraud. And the reason the OLA report cited the 5 to 6 million is because that was the amount that had been convicted by the time the report was written. So the OLA was only acknowledging the amount that was found in court. They weren't talking about what was potential fraud in all these other situations. And then when the OLA reports came out in March and April of 2019, they were pretty damning and pretty explicit, and the whole email that the criminal investigation unit director had sent to the OLA was put in the appendix. You can read it right now. It's in the appendix. It starts on page 49. And in that OLA report, they called for a lot of reform in the CCAP program, and they recognized that this was an ongoing problem. And interestingly, then the speaker at that time, according to then OLA Jim Nobles, was forbidding committee chairs in the House of Representatives to hold hearings on the OLA reports. So hearings were never actually held in that point in history on these OLA reports because they were forbidden. So this never really got the light of day. So that summer, rather than seeing this huge problem of CCAP fraud and doubling down on investigations, the Walz administration closed the criminal investigation unit in DHS. And they forbade the criminal investigation unit members from speaking to the BCA without supervisor approval. And they removed the BCA from the Department of Human Services, so they weren't even in the same building. So this is the state of play, members, and it was kind of swept under the rug all these years. They didn't do any more criminal investigations of child care fraud. It all became overpayment fraud. And it all went to a committee to determine if there were, in fact, overpayments, and the committee would decide if they were going to try and recoup the money. Criminal investigations ceased. And that is why we have an urgency, because all these years, this was not being done. And now we need to modernize our child care system. We need to require that the attendance records are true under penalty of perjury, and we need to have this electronic billing moving forward. So thank you, Representative West, for bringing this forward. Members, this is an easy green vote. Thank you.
I recognize the member from Olmsted, Representative Quam.
Thank you, Madam Speaker. And even during the time that was referenced where chairs didn't hold hearings, the Legislative Audit Commission did meet, did look over these audits, did look over materials sent by whistleblowers. The stuff we're seeing now is huge, large-scale entities stealing hundreds of thousands, millions of dollars. In the early CCAP stuff, it was a lot of small but large scale across, so they'd have apartment buildings where the parents would get together and they would be paid to take care of the neighbor's kids, and the neighbor was being paid to take care of their kids. And the scam was they were just collecting the money and sharing that, as opposed to having it be child care. There was one family where the mother and the grandmother arranged for 8 kids that were being full-time taken care by the mother, and there were indications that was fraud, but there wasn't the investigation, the going after these people. They were predominantly low-income people, but the shift happened during that same period of where there were entities that were doing a little more of the larger scale. And again, it was stated earlier, there were an investigative team, and they were checking into it. And that was happening around the transition between the Dayton and the Walz administrations. We started hearing that from whistleblowers that they were being told, no, you are not reporting, giving, etc. What was worse is when we had audits and there were discrepancies, there were problems, there were issues, we asked the commissioners, was there any disciplinary action, retraining, etc.? And they continued to say no. The knowledge about everything going on was well known because of the quantity of whistleblowers, but they ignored it. It didn't matter. We tried and moved some stuff to try and put things in bills and other items. The next evolution was they would not only not do stuff, when an audit came, they would falsify documentation. Now, it was normal for the auditors to check everything with the agencies, but because of the whistleblowing, because of the conflict between what they're hearing was different than what they were seeing in the documentation, the audit teams actually looked at the documentation in the agencies, and then went and checked the sampling of the people that were being paid, the other entities. And that was how they were able to prove the falsification they were being told about was proven, and it was true. So I do not understand how we as a legislature can sit by when we know for a fact the agencies aren't doing their job. And apparently there's some very interesting stuff on your displays because you don't seem to understand this progression started years ago and has climbed and got worse because we, the legislature, have not passed what is required to be done by the agencies. We abdicated the rulemaking. We abdicated the actual requirements to do their job. And that is what we are not doing now, that we should be doing, is looking at the evidence, looking at the proof in the different audits, taking what the auditor and the whistleblowers have given us and doing the right processes. And frankly, I think the people watching are paying more attention than many of the members on this floor, because this is not trivial. Because every program that we fund and it gets stolen, the people that need the help, the people that are in need, aren't getting it. We talk so much about, oh, this is a wonderful program. We fund it, but we don't care that the agencies don't do the oversight. They don't do the due diligence to make sure the people that actually need that assistance get it. And frankly, this bill would help some, but there's a whole lot more that we should pony up and actually do the work we're elected here to do and ensure that the oversight activities, the implementation, the actual doing the job rules are effective, that they're doing the job. But I'll sit down because apparently it's not important enough to take every single step forward of an opportunity to fix a problem. It's not the dollars, it's the people. We're here to help those people. So let us vote and help those people. Thank you.
I recognize the member from Hennepin, Representative Sensor-Mira.
Thank you, Madam Speaker. I'm listening, Representative Klom. I'm in the conversation. Appreciate those remarks. So I am, thank you, Chair West, for bringing this up. I agree that there's an urgency around childcare. I agree that there is an urgency around affordable childcare. And I agree that anyone that is taking money that's supposed to go to our kids needs to be held responsible. And anything that we can do with our system to make it easier to hold those people responsible, I'm for. I do have some questions, though, about this bill. We've talked a lot in the Children and Families Committee about video monitoring. We've had conversations. Is video monitoring about catching fraud? Is video monitoring about catching abuse? Is it about prosecuting abuse? In this bill, as I understand it, you're specifically trying to tackle the fraud. But I know we've had a lot of conversations around video retention, and I've heard you yourself say having timeline for retention of the video is really important, because this is a closed system, as I'm understanding it. It is not like we have Commissioner Tiki Brown sitting in a room with like 100 computers looking at the entrances to all the different CCAP centers, right? That's not the way it works. So is there in this bill, Chair West, if he would yield to a question, Madam Speaker?
Representative West will yield. Representative Sensor-Mira.
Is there a retention timeline for the videos that we are asking these centers to keep?
Representative West.
Yes, that is something I glossed over here. The retention period in the bill is 90 days, and the department actually had a conversation with us about increasing that because they said 6 months would be ideal for rooting out fraud. However, you know, once you clear 90 days, that cost goes up dramatically. 90 days of data retention is very, very affordable. Once you clear that 90-day threshold, the prices go up dramatically. The centers we're talking about here get $500,000 or more of CCAP money. So that is the thought that it'd be an affordable measure for them.
Representative Sensor-Mura.
Thank you, Madam Chair, and it's really not a got you. Chair West, can you actually show me where that is? I'm not seeing that language around retention anywhere in the bill, but maybe I'm not looking at the right version.
Are you asking Representative West to continue to yield?
Yes, sorry, if you would yield to another question.
Representative West.
Well, I don't have it right in front of me, so I can't tell you.
Representative Sensor-Mura.
Thank you. I mean, I did a Control F for retention. I did not see it. So I'm concerned about that. And the reason that I'm concerned is you yourself have said that video retention is incredibly important for prosecution. And I would believe that what we'd be trying to do if people are to be held accountable for fraud would be to prosecute them, to hold them accountable. And so we would want to make sure that if this is a closed circuit system, again, it is not like the commissioner is sitting in a room and watching this video as it is happening. I don't think that's the best use of her time. I don't think that's what we want her to be doing. Then we would want to make sure that the video centers are retaining that video so that the department would be able to follow up with them. And what really concerns me about the retention piece is if we go to lines 12.16 to 12.20. So this says the commissioner may request and review recordings or copies of recordings of a licensed provider's operation from certain times and dates. If the licensed provider fails to produce recordings or copies for any of the requested times and dates, the commissioner will use that failure as prima facie evidence that the licensed provider cared for 0 children during the missing times and dates. So I'm really concerned that we are not being clear with this language to providers for how long they should be keeping their video for. And then that to me sounds like at any time if the department comes and says, please produce video from, I don't know, 6 months ago, a year ago, and they are not able to produce it, then we take the lack of that video evidence as evidence that they served 0 children during that time. That feels like a really high bar to me. Can you speak to that, Chair West, if he would yield for a question?
Representative West will yield. Representative West.
Thank you, Madam Speaker. And the reason I said the 90 days is because that was one of the amendments in committee that was adopted when we heard this bill. So that would be the intention, is 90 days. The department, again, wanted more than 90 days. 90 days is affordable, and so that would be the time range in which the commissioner would be requesting said data.
Representative Sensor-Mura.
Thank you, Madam Speaker. Thanks for that clarification, Chair West. Yeah, I don't think that amendment, made it on there because the bill didn't get out of committee. So that's helpful. I am concerned because I do think that this bill also relies to speaks to the underlying statute, which is 28 days. So I do worry that that could be a little confusing, that the current law says you need to keep it for 28 days. Now we're saying 90 days. I do have a real concern about clarity for the video retention and making sure that we are setting our centers up to be successful. Another question that I have, Chair West, if you would yield to another question, Madam Speaker.
Representative West will continue to yield. Representative Sensor-Mura.
Thank you. So affordability, you spoke to this at the beginning. I think it's a shared value that you and I have. We both have 2 young kids. We both know that childcare is incredibly expensive. How does this bill help with affordability of childcare?
Representative West.
Thank you, Madam Speaker. Well, right now, when we suspect people of fraud, it is ridiculously difficult to get those to conviction. And One of the big problems in that is the lack of hard evidence, and that is what this bill resolves. So if we're looking at what I know will be massive numbers, if it wasn't going to be massive numbers from these FBI raids into Minnesota on these child care centers, if it wasn't going to be an absolutely staggering amount, I am sure Governor Walz's statement would have been more like, oh, federal government bad, don't listen to him. But instead it was, we're working hard to root this out, because this problem is substantial, and that is why it has attracted so much investigation. And when taxpayers see how many of their dollars are going to fraud, they're going to be mad, and justifiably so. And then we can recover those dollars and have them go to the families and providers that need them, which will result in more affordable care for everyone.
Representative Sencer-Murra.
Thank you, Madam Speaker. Well, I did not hear you, Chair West, speak to the cost of the cameras, which is something that we have heard child care providers come again and again and talk to us about. I know that you've heard the concerns from our side of the aisle that maybe you can do camera systems on the cheap, but when we are trying to keep our kids safe, when we are worried about who can get that material, we're looking at incredibly expensive systems. So if we already are one of the most expensive states for childcare, if we already have families that are paying more than $20,000 for childcare, we're asking them to install these camera systems. It will either be the state paying for those systems or our centers paying for the systems. And we have heard from centers that this is the needle that will break the camel's back, that if we ask them to have one more cost, like putting in these cameras, that they will literally go out of business. That is what the child care centers have told us. But I do wanna, you said something about investigations, and the last question I have for you, Chair West, is around that. Will he yield to one more question?
Representative West will yield. Representative Sencer-Murra.
Thank you, Chair West. Did your caucus give Nick Shirley the list of the child care centers?
Representative West.
Thank you, Madam Speaker. No. But what we do know is that there were 20-some raids in the Minnesota child care centers. There's been numerous child fraud scandals in Minnesota to the tune of billions of dollars. We have 80-plus people who have been charged and many convicted on the Feeding Our Future scandal, and that's $250 million right there. We're looking at a very, very frightening amount of fraud in our state. And if we aren't going to do anything, if we're just going to sit here and let the fraudsters fleece the taxpayer, that just doesn't sound right. So if you have over $500,000 a year of tax dollars, you probably already have cameras, but if you don't, well, we actually do have a technology fund to help you pay for it, and it is affordable. So it blows my mind that we wouldn't do anything to deal with the billions of dollars of fraud, and it seems like that number is only going to get larger. And that is something that taxpayers are sick of, and we need the money that goes to people who need the assistance should get to the people who needs assistance. That's something that everybody in this room agrees to, and this bill will help that happen.
Representative Sencer-Murra.
Thank you, Madam Speaker. So what I heard you say, Chair West, after some kind of fumbling was that no, your caucus did not. I believe that that is actually in direct contradictions to statements I read from Madam Speaker, that actually it was your caucus that gave them that list. So it seems like one person in your caucus right now is not telling the truth about their actions. And I'll say why I'm pressing on this. Because people in my community have the lived experience of your caucus giving a 19-year-old right-wing YouTuber a list of businesses in our community that sent our president on a mission to terrorize our kids. That is why it matters that someone in your caucus is not telling the truth about how that started and the GOP House caucus's direct involvement in that. Thank you, Madam Speaker.
I recognize a member from Ramsey, Representative Pinto.
Thank you, Madam Speaker. So members, let's just sort of stop and review where we are. So the motion is to declare an urgency to pass this bill 3819 relating to purportedly addressing fraud in CCAP. Is fraud an urgent problem? And absolutely is. I'll note that the fraud has been said by several of my colleagues that fraud, when it comes to childcare, of course, is depriving kids from opportunities to learn and parents from opportunities to work. So that's incredibly concerning. Having said that, this particular proposal was heard in a committee. There was not agreement in that committee, didn't advance at that point. It lacks a Senate companion. Maybe I will ask Chair West, if I can, if he'll yield, Madam Speaker, a question.
Representative West will yield. Representative Pinto.
So, Chair West, this bill was introduced on March 2nd. You say that it's very urgent that it pass. It has no Senate companion. Is that because you have not tried to find a senator to introduce a bill, or the senators have all refused you? Which one?
Representative West.
We need to move this bill forward, and it would be a travesty of the Senate not to move on this bill. And there is time to move on the bill, so let's take the step to address this ridiculous problem. Billions of dollars in fraud. It's just something that we shouldn't let go on. And sure, things have been done to nibble around the edges, but clearly we haven't done enough, and it would be a shame to leave this legislative session without doing anything about it.
Representative Pinto.
Thank you, Madam Speaker. So, Chair West, your actions speak louder than your words, sir, because this bill was introduced on March 2nd. So either you weren't trying or the senators have all turned you down. A document's been distributed on the floor that says Summary of Minnesota Legislative Changes to Support Program Integrity. These are the changes to the CCAP program since 2018. It's interesting. So this topic seems to be sort of a greatest hits thing. There was an OLA report from 7 years ago, and somehow we keep on going back to it. I've heard a number from that CCAP report of $100 million. A reminder, the report said there was not evidence of that number. Now, am I saying that it's not very important we go after fraud in any of our programs, including CCAP? I'm certainly not. But it's just interesting. We keep on going back 7 years. Members, in the ensuing years, this 4-page document, quite dense, shows all the various changes that have been made. Many of those changes had bipartisan support. Obviously, in 2019 and 2020, 2021, there was a GOP Senate. We're working together. In 2025, we know that last session there were a number of changes made as well, quite a lot in 23, 24. And yet somehow we keep on jumping back 7 years. I'm going to jump back 2 days to, as Chair Robbins noted, there was a fraud committee hearing on childcare. I was present for that hearing. I heard the chair say just now that this is essential. This is so essential, apparently, that nothing in this bill came up 2 days ago. Now, a reminder, the Fraud Prevention Committee does not actually hear bills to prevent fraud. We've passed one bill, acted officially on one bill. But even setting that aside, members, an entire hearing about child care and something so incredibly essential that we have to move it through, no Senate companion, blocked in the chamber, and yet somehow nothing in this bill came up 2 days ago. Nothing, nothing, nothing. What did come up was the assertion that criminal investigations have ceased for child care. Completely not true. As untrue as various assertions made in the Nick Shirley video. Members, it's true that the criminal unit within DHS at the time has now been moved to the BCA, the Bureau of Criminal Apprehension. What do? They apprehend criminals, including those that have committed fraud. Criminal investigations absolutely have continued. The statement was made during the committee meeting 2 days ago that somehow criminal investigations ceased. Nope. That was corrected. In fact, the folks from Department of Children, Youth, and Families who oversee this program were asked, wouldn't it be helpful to have criminal investigators in your agency? They explained why that would not be helpful. Now, one thing they were not asked was, would it be helpful to have one of the provisions of 3819? Would that be helpful? Would that be harmful? What's your opinion about that? Not asked about that. Not asked about video recordings. It's essential that this thing pass, and yet somehow it just doesn't end up coming up. Members, we as a body have taken quite a lot of action relating to child care over the past number of years. It's unfortunate that when we have somebody come from out of state and go to various individual child care providers, bang on the door and say, I want to see children, and then there's not a response there, then somehow that resurrects this thing from 7 years ago. Members, there's a lot of important work to be done. I am grateful to the various committees and the co-chairs in those various committees who have done a lot of great work to address fraud in various programs. I'm looking at you, the Human Services Committee, the Health Committee. It's unfortunate that in the Children and Families Committee, it sounds like there's not been agreement to move a number of non-controversial provisions out. Members, this is a bill, 3819, that didn't have the support in that committee, didn't have the support in the Fraud Committee, if you can thought about it at all. There was apparently no urgency to try to move this in the Senate. Members, let's actually move things that will address fraud. I'm not on the Children and Families Committee. I can't address the content of this bill. I think Chair Katiza-Wattoon, Representative Sensimura did very well. I'm just letting the actions speak louder than the words. And members, the actions would say, this is not a thing that's essential, but many of the other steps we're taking to address fraud, thank goodness we are doing that. It's critical that we do. Let's get back to that work, but reject this motion. Thank you, Madam Speaker.
I recognize a member from Hennepin, Representative Robbins.
Thank you, Madam Speaker. I just wanted to jump up and address a little bit of what was just said. I wish I had time to print out this article from Jim Noble's, the OLA at the time of those reports, but he submitted an op-ed on October 22nd, 2025 in the Star Tribune that I recommend to everyone to read. And basically, if I can find it, he said, he said state officials, particularly in the Department of Human Services, but in other departments as well, allowed community organizations to administer important programs without first verifying they were trustworthy. Then they failed to verify claims from these organizations that were serving hundreds, even thousands of people in their communities. And then he goes on to talk about his reports. That is still going on. We had the example of many of these things in the committee on Tuesday. And to address Chair Pinto's point, we're an oversight committee. We are not a legislative committee that hears a lot of bills. That's not the design of an oversight committee. This is the first time the legislature has had an oversight committee, so people kind of misunderstand the role sometimes. But our job is to expose and take a broad look at what's going on across agencies and provide oversight. And that's why we have these hearings, so that we can expose things and then work on, in a bipartisan fashion, which we have done on many occasions, ways to strengthen internal controls when we have found areas where there are gaps. And we continue to find these areas of gaps. We continue to work in bipartisan ways to bring bills to the floor that usually don't even go through our committee. They go through State Gov or other committees that then address the gaps we have exposed. A good example is the OIG bill, which I think is moving, and I hope we get that across the finish line this session. We're also trying to get an extension to the statute of limitations. I did a whole hearing a couple of weeks ago on the governor's fraud proposals. So we are taking a look at all these proposals. Last year we got good bipartisan work done, expanding whistleblower protections, requiring more oversight in different DHS programs. So the work that we do in oversight leads to good legislation, and I'm very thankful for that partnership with the policy committees. But what really happened in 2017 is that the Criminal Investigation Unit was shut down, and they were not allowed to talk to the BCA without supervisor approval. And the people who ran the Criminal Investigation Unit were not transferred to the BCA. They either resigned or were let go or were reassigned. They weren't transferred over to continue their criminal investigations. They were not allowed to continue their criminal investigations. So we have to be very clear about what happened. The BCA does conduct criminal investigations right now. They gave us a chart in committee, and I wish I would have known we were having this debate, because I would have brought all my materials from committee. But there was a chart that was provided to us by DCYF where they showed how the criminal investigations have fallen off since this unit was closed. There have been 2 convictions. 2 convictions since that happened, and they had 15 active cases. So members, we are not getting the criminal investigations done, and this is a huge problem. And so this bill does take up some of the basic things that need to be done. I'm glad that they addressed electronic attendance records last time. We need to do that in more areas. I had a whistleblower literally call me today talking about how we need to do that in adult day services. So I hope that the Health and Human Services Committees will take that up next year. We need to have these electronic attendance records. We had a hearing on non-emergency medical transportation. We're trying to get a bill passed this session that would improve internal controls by having GPS tracking so that we know that these transportation companies are actually doing the routes they say they're doing. This is just one example of one of the many vectors of fraud that we have a responsibility to address to stop taxpayer money from being spent by criminals, by being stolen by criminals. And if we drop the ball on the criminal side, there's no deterrent. We had testimony to that this week. When they stopped doing criminal investigations, the deterrent stopped. And what happens is they get sanctioned for overpayments, and a new group pops up, and it's often someone related or in a business relationship already, and they just open a new group at the same location under the same name. And that happens all the time. The Feeding Our Future group called Future Early Learning Childcare, they closed on October 1st, and it opened the next day under a new name. Like, that is happening in real time in Minnesota right now. And I think, I can't believe we're not at the point where we're willing to take this seriously after all the hearings and all the attention, but this is our responsibility to safeguard taxpayer dollars and make sure Minnesotans in need of these services can have them. And so I hope we will take that seriously and pass this bill. Thank you.
I recognize the member from Anoka, Representative West.
Thank you for the lovely debate on this motion, members. So Minnesotans are done giving the benefit of the doubt. Honestly, I think the idea was, oh, we did some things. Oh, okay, this is going to be taken care of. Clearly, it's not taken care of. They expect us to do something. And the idea that we're only, getting at 6% of this, that's exactly why we need this bill. The loopholes are enormous. The job of investigators is insurmountable almost. The fact that we're relying on the federal government to do the work for us, to prosecute the fraud, that's only going to work after the money's left our state and is traveling overseas and we can get the federal government involved for international wire transfers and the like. So we need this bill, or else we will just see this fraud continue and they'll get away with it. So members, please support the motion.
I recognize the member from Dakota, Representative Hanson J.
Thank you, Speaker. Folks, I think we all are in agreement that the misuse of taxpayer dollars is entirely unacceptable in any way, shape, or form, right? I don't think anybody disagrees on that, and I want that to be really clear. It's absolutely deserving of our continued and utmost attention and action. But I really warn you to fall for the fallacy that this bill does that. This bill has not been done in collaborative work, and I go back to the comments I've made here a bunch of times about doing the work. It does not mean that we cut corners on policies that impact children in Minnesota. The topic of cybersecurity has been discussed about this bill and others like it many times. The maker of the motion has been asked to incorporate cybersecurity measures and guardrails several times last year and several more times this year. And despite a commitment to do so last year in the current statute that requires cameras at centers with maltreatment reports, nothing happened. That still has not happened today. And cybersecurity matters in situations like this, and especially in policies that have little to no precedence anywhere else on the planet when monitoring and putting surveillance on kids like this. We just passed my bill the other day to ban the use of notification technology in AI. All of us, most of us, almost all of us, passed that bill. And we all spoke about how important that was. And while I was listening to that, there were some contradictory statements that had come up in committee about this very topic. When I raised these concerns in committee about this this proposal. And again, it's not about anybody disagreeing on whether or not it is important and our responsibility to address the misuse of taxpayer dollars every time we can. But just because we voted to ban this technology in Minnesota does not make that apply in any other state or any other country on the planet. The EU is working on this, but we did better than the EU by getting this policy in place. And so for all of you who voted for that because you agreed that that was something we should care about, you should know this. The footage of infants and toddlers is the most sought after material by these disgusting predators that make this material, that makes AI-generated CSAM. Infants and toddlers, they can't get their hands on the same kind of content to feed into the models to make it real enough for these pedophiles to be satiated. I do not think that we should put up a flag to the world and say, look at what we have, a panacea of databases that are on closed circuit cameras with no other cybersecurity measures, and say, let's just put that out there and leave it as is. That feels entirely irresponsible to me. So if you voted to support the bill the other day on the premise that the 26,000% increase in the AI-generated child sexual abuse material was problematic and you wanted to do something about it, I'm so proud of us for doing that. We should be so proud of us for doing that. Then this is a similar situation where we need to think thoroughly and critically before we jump to do this. The current mandate we have on the centers that goes into effect this summer, centers with maltreatment reports, has no cybersecurity measures. Closed circuit TVs, closed circuit cameras is not cybersecurity. And you should not be fooled to think that it is. I will never, and neither should you, ever sign your name to a vote that will put our children, Minnesota infants and toddlers and kiddos going to daycare, as the potential subjects of the first of its kind on the planet, panacea of footage and collateral, to become the subjects of AI-generated CSAM conducted in other states for the next century or more. Protect our kids from this. We agreed that this is a threat to children, and we have to think thoroughly about this. Had we seen different cybersecurity measures be intentionally, meaningfully, and thoroughly vetted with the experts I brought to the committee to do this, if we had seen those efforts, if we had seen that in this bill or even in a subsequent one introduced, I wouldn't be having this conversation with you today. But I raised the alarm about the feature that we banned the other day, and I'm raising the alarm again here. We cannot think that the actions we took will prevent our kids from becoming the subjects of that if just because other states and countries haven't banned that technology. It's still going to exist everywhere. We are just leading the way on that. So please, please do not make a decision that is going to put us in this situation. Please vote against this motion. Thank you.
I recognize a member from Anoka, Representative Niska.
Thank you, Madam Speaker and members. For years, House Republicans have stood in this chamber and warned that Minnesota Child Care Assistance Program was vulnerable to fraud. And for years, we got the same response, a similar response to what we've heard today, dismissing warnings, at times even laughing at or mocking those concerns. We've been told that the system is working, that our concerns are overblown. And Representative Robbins, thank you for mentioning that op-ed from Jim Nobles of October from last year, because he said some pretty interesting stuff about the problem with this body as it relates to efforts to minimize the fraud. And we heard, just like the efforts we heard tonight, Mr. Nobles said that when he issued that report, so, quote, some key legislators tried to minimize the fraud problem and shield the Department of Human Services and the Walz administration from criticism. I noticed particularly significantly for this debate, as actions speak louder than words, he said, quote, the chief House supporter of publicly funded child care subsidies criticized the OLA report for referencing prosecutions that have proven fraud in the child care program. The references were unnecessary and harmful, he said. Well, members, We have seen the same story over and over and over again in Minnesota's multi-billion-dollar fraud crisis that has put our state on the map for all the wrong reasons. Weak safeguards, delayed action, millions of taxpayer dollars lost, and CCAP is a huge part of the problem. And we saw it just this week, how urgent this is. Federal law enforcement executed search warrants at 22 locations across the Twin Cities, many tied to child care fraud. And we heard even efforts to kind of pretend like, oh, that was bad. ICE maybe was involved in that, at the same time as the governor pretended like he was actually responsible for helping it happen. Of course, the director of the FBI debunked that, but it'd be nice if Democrats could at least keep their story straight. The reality is, the 9 centers that were just rated accounted for about $14 million in CCAP just in fiscal year 2025. How many kids could that have been used to help with child care? Child care is expensive because Minnesotans are paying a fraud tax, and that fraud tax is the result of years of inaction from Democrat administrations and minimization from Democrat legislators covering for those Democrat administrations. So the federal government has had to come in to clean up the mess that was left behind. I heard from someone in the fraud committee on the other side of the aisle talking about what happened in that fraud committee. He didn't happen to mention the shocking thing that we learned in that fraud committee. Not that shocking if you're paying attention, but still confirming what we've heard from the U.S. Attorney. A former manager in the Office of Inspector General at DHS testified that individuals involved in the child care scams told investigators that they first heard about Minnesota and the opportunities to defraud Minnesota in refugee camps in Kenya. Just like the U.S. Attorney a few months ago, in announcing some more prosecutions, said, we have people coming from Pennsylvania to Minnesota, fraud tourism in the state of Minnesota, because they know that we're such an easy mark. That's the reputation that Minnesota has, not just across the country, but across the world. And the consequences of that are real. They're real for the families that have to pay that fraud tax. They're real for the legitimate providers who are forced to compete against bad actors, leering centers, and other bad actors. And you can complain about a 19-year-old using publicly available information and exposing that to the world. The reality is, our state regulators should have been cracking down on that long ago. And our state regulators should have known the facts when they pretended to debunk some of the facts in those videos, and it turned out that they were not telling the truth themselves. They were taking the lies of the leering center proprietors and just saying that was the truth. And they admitted just the same in the fraud committee hearing that we've discussed. So members, we have to keep in mind what's really important here. The people paying the price for the fraud aren't the fraudsters. They're the families who need child care, who have to pay a fraud tax. They're the honest providers trying to compete on an uneven playing field. And this bill is a chance to start fixing it, to restore trust, to send a clear message that Minnesota will no longer be an easy target to fraud. As we heard today, actions speak louder than words. Actions speak louder than words. A green vote says you're serious about solving this problem. A red vote says you're not. Members, vote green.
The clerk will take the roll. The clerk will call the names of the members participating remotely.
Green.
Green votes no.
Green votes no. McDonald. McDonald.
McDonald, aye.
McDonald votes aye. Momani Hildsley.
Momani Hildsley, no.
Momani Hildsley votes no. Perez Vega.
Perez Vega, no.
Perez Vega votes no.
The clerk will close the roll. There being 63 ayes and 67 nays, the motion to suspend does not prevail. There's a motion at the desk. The clerk will report the motion.
Long moves that the rules be so far suspended so that House File Number 76 be recalled from the Committee on Energy, Finance, and Policy, be given its second and third readings, and be placed upon its final passage.
I recognize the member from Hennepin, Representative Long, to your motion.
Thank you, Madam Speaker. That's my motion, and I would defer to Representative Greenman to describe her bill.
I recognize Representative Greenman to the bill.
Thank you, Madam Chair, or Madam Speaker. This bill will help lower Minnesotans' utility bills by limiting the amount of executive pay that investor-owned utilities can charge back to Minnesota ratepayers. And we need to do this bill now. I think you'll get handed out to you an article that happened a couple weeks ago that in Minnesota we learned that Xcel's CEO, Robert Frenzel, got a 45% raise. And this is a time when Minnesotans are struggling to pay their utility bills. Xcel decided to give a $4 million raise, and CEOs want Minnesotans to pay for it. But this bill is our chance to protect Minnesota ratepayers from having to foot the bill of the millions of dollars in executive pay that private investor-owned utilities want their CEOs to make. This bill protects ratepayers. It does not, they can decide to pay their CEOs whatever they want. But this bill says you can't charge it back to ratepayers. It caps what private utilities can charge to ratepayers at the level of our chief executive, the governor. Minnesota ratepayers should not pay more for the CEO of Xcel or CenterPoint than we pay our chief executive. Customers pay for utility service, not excessive CEO compensation packages. And while utility bills rise for folks across the state, this bill protects Minnesota ratepayers from being nickeled and dimed by the private investor-owned monopolies that pay for lavish compensation for their CEOs. This isn't a hypothetical problem. These investor-owned utilities are making big profits at the same time Minnesotans are just trying to pay their utility bills. In 2025, so last year, Xcel made $2.2 billion in profits and sought to charge Minnesota ratepayers $7.3 million for its highest 10 paid executives, and this year in 2026, $7.6. And for anybody who says this bill isn't necessary, tell that to the Minnesota families struggling to pay their gas and electric bills. Because Minnesotans are the ones on the hook, while executives at these compensations, at these companies can afford it. And they can afford it. They're making $16 million a year. So here's our deal. Rest assured, these executives, they're not going to struggle to pay their utility bills. But for the Minnesotans who are struggling, this bill will help them afford their utilities, and this is an easy green vote. And Madam Speaker, I'd like a roll call.
A roll call has been requested. Seeing 15 hands, there will be a roll call. Further discussion? I recognize the member from Lyon, Representative Swedzinski.
Thank you, Madam Speaker. Thank you, members. Would Representative Greenman yield for question?
Representative Greenman will yield. Representative Swedzinski.
Thank you, Madam Speaker. Representative Greenman, just kind of talking about it, we talked a little bit about this bill in committee, House File 76. I forget kind of what from a conversation standpoint, kind of what kind of impact do you think that would have on ratepayers if your bill would, maybe an individual, what kind of an impact that would have on an individual ratepayer per year?
Representative Greenman.
Thank you, Madam Speaker. I don't have, and I think because we're talking about a future decision that we would restrict, don't have it in front of us. What I do know is the PUC took this action to try a couple of years ago to cap these rates. What we do know is if they are charging ratepayers millions of dollars in compensation that goes directly to Minnesotans, that has an impact. And anything we can do to lower that impact is a good idea. We are not saying that CEOs can't pay, that Excel can't pay Robert Frenzel $60 million. What we are saying is the amount that they can charge to ratepayers has to be capped at the amount that the governor makes, because that's what we pay our chief executive.
Representative Swedzinski.
Thank you, Madam Speaker. And just maybe a follow-up to Representative Greenman, if she would yield again.
Representative Greenman will yield. Representative Swedzinski.
Thank you, Madam Speaker. Just from a standpoint, I kind of remember maybe it was like $7 million potentially this would impact ratepayers or investors, or I think it could be debated whether it's ratepayers or the investors' side where some of this compensation comes from. Would you agree that it's about $7 million?
Representative Greenman.
Thank you, Madam Speaker. I think the $7 million you're talking about is in 2026. Excel asked $7.3 million of their compensation to be charged to the ratepayers, 7.6 in 2026. That's just Excel. So that doesn't include CenterPoint or the other investor-owned utilities who would be covered. And Madam Speaker, this is just the amount that they want to charge back to the ratepayers. How much investors pay for compensation isn't a part of this bill and isn't a part of that figure.
Representative Swedzinski.
Thank you, Madam Speaker. And I think that is true, that a vast majority of compensation does come from the investor end of this. And I do appreciate the idea of the bill when it comes to saving a ratepayers' compensation. And it's my understanding, Madam Speaker, if Representative Greenman would yield for one more question.
Representative Greenman will yield for one more question.
Thank you. That's it. I promise.
Swedzinski.
Thank you. Representative Greenman, what does the governor make per year?
Representative Greenman.
Thank you, Madam Speaker. I believe it is this year, the Compensation Council sets it. I think it's around $177,000 in 2026.
Representative Swedzinski.
Thank you, Madam Speaker. And I think, I believe the motion just prior to this was to bring House File 3819 to the floor, which was talking about fraud and recovery of fraud dollars. And if you remember some of the numbers being thrown around, that was about $9 billion that the state of Minnesota has lost under the leadership of Governor Walz. And I think when sometimes, folks, you get what you pay for. $176,000, I think most Minnesotans would argue, is entirely too much money. Friends, when we're talking about fraud and we're talking about the realities of impacts on ratepayers, when we're talking about the impacts and the impacts on taxpayers, we are talking about real dollars, friends. $9 billion. Representative Greenman said it potentially could impact ratepayers $7 million if this bill would move forward. Wow. All right. So when we have jurisdictions, when we have things that we oversee, and we say, you know what, $7 million is going to impact ratepayers in a major way in our state of Minnesota, what would be the ramifications of that? We might drive some talent from Minnesota. I know we're seeing that with Health Partners. We're seeing that with Target. We're seeing that with other large businesses leaving our state when it comes to CEOs, job creators, visionaries, people that are making the economy grow here in Minnesota. And what is the DFL's majority answer to chasing folks out of our state? Let's chase them a little harder. Friends, $7 million does impact. If we were serious on this House floor about impacting ratepayers in Excel territory, we have current funds sitting in the RDA of over $50 million that on Monday we could bring to the House floor with the DFL's help and return $50 million that are in our accounts as state legislators and return it right back to those same ratepayers that we seem to care so much about. $7 million, friends. Chasing talent out of our state, channeling some of the best minds when it comes to energy and energy distribution, and coming up with markets and coming up with how we are going to envision what our energy policies will be here in our state of Minnesota. And tying it to a governor that, quite frankly, has been asleep at the wheel. $9 billion in fraud. Friends, this is a distraction. The DFL majority just asked 15 of its members, and some of ours, to raise their hands. And why? Because they want a roll call vote. They want each and every one of you on this House floor to say, you know what's more important? We had House File 3819 that could have brought some real reform, that could have brought real dollars back to taxpayers, $9 billion. Instead, we're sitting here playing kangaroo court for $7 million of executive pay, when we have $50 million in our own pockets of RDA dollars that this DFL majority refuses to give back to ratepayers. Says St. Paul knows best, not families, not business owners, not schools, not counties, not our jails, not how they spend the dollars best, but how we here in St. Paul, here in this room, us 134 members, how we spend it best. Friends, the answer is clear. Make your choice. If you're looking just for a high line or a headline, vote green. But if you want to make real impacts on ratepayers, if you want to make real impacts on the taxpayers that have, quite frankly, had enough of Governor Walz, has enough of the DFL majority's inability to rein in fraud, kicking and screaming in Ways and Means last night. Friends, we have a job to do. You can vote green tonight. You can declare an urgency over $7 million, or you could have done literally billions in the bill before. Friends, we could bring an energy bill that would make a real impact when it comes to ratepayers. One of the last bills we heard in committee would have returned over $3.6 billion to ratepayers. By what? Putting ratepayers first and saying, state government, get out of the way. Whether it's reform in a number of programs, a number of mandates, a number of forced spends on the behalf of political will on our ratepayers across the state, nuclear cask fees, carbon-free by 2040. The market will find balance unless the thumb of government is weighing heavy on political friends. Friends, I would recommend a no vote on this motion. Because if you want real reform in government, first we need to get out of the way. Friends, if you want to empower bureaucracies, if you want to empower a governor who, quite frankly, has been asleep at the wheel and tie executive compensation to some of the best decision makers we have in our states when it comes to energy policy, vote green.
I recognize the member from Hennepin, Representative Acomb.
Thank you, Madam Chair. I found those remarks by Co-Chair Swedzinski interesting when he talks about asleep at the wheel. That's how I can describe his participation in committee this session. We had
point of order.
Bills.
State your point of order.
Madam President, members, we have Masons. We're not supposed to invoke personalities. It's absurd what we just heard on the floor of one co-chair invoking the personalities of another. That's uncalled for. Please rule the speaker out of order.
Members, confine your comments to the subject at hand, which is the suspension of rules on House File 76. Representative Acomb.
Thank you, Madam Speaker. We'll circle back to Representative Greenman's bill. And we in Minnesota have utilities, especially our investor-owned utilities. And in essence, they are given a monopoly market in exchange for regulation and oversight. And when we have a utility that has no competition and no other place for customers to buy their energy, it can become a problem. And so, as the bill that we have before us talks about, we want to ensure that the ratepayers in that utility jurisdiction are not paying for excessive executive pay. We're not saying that the utility can't make or offer excessive executive pay. The shareholders can pay that instead of the ratepayers. What we're seeing in Minnesota and all across the country right now is an energy affordability crisis. They indicate when your household bills, when your energy bills of your household income are more than 6%, you're energy burdened. And there's a lot of people in Minnesota that are energy burdened right now. And that continues to, those numbers continue to grow, especially in reaction and in response to some of the actions at the federal level. We have, in Minnesota, we buy a lot of electricity and oil and natural gas from Canada. And now we're impacted by the tariffs that the federal government have put on Canada. So that's, again, another way that we are impacting ratepayers. Minnesota is a part of a regional grid, MISO. And so everything that goes onto that grid and it's sold in a market. And because of actions, we're in the Midwest market, and because of actions from the federal government that are preventing planned closures of dirty and expensive coal plants in other parts of the country, again, it's impacting ratepayers here in Minnesota. In committee this year, we heard that because of the extension of a coal plant in Michigan, it will impact Minnesota ratepayers at the cost of $45 million. And that's just one plant. There were 2 additional plants in Ohio that have also been extended by President Trump. So as we look at reasonable caps on executive pay, similar to what our state executive is being paid, that is a reasonable amount of money to expect ratepayers to cover. We heard this bill in committee and heard testimony from impacted people, and we had a vote on that bill that day, and it passed on, or excuse me, it didn't pass in our 50-50 committee based on party line votes. The Democrats supported reasonable caps and accommodations to ensure ratepayers are not being overly burdened by excessive executive pay. The Republicans didn't see it that way, and they voted against it. So as we look at that decision and many others that we heard in committee, many other bills, many other hearings that we had, and the lack of willingness to come out of committee with any kind of a bill, even on things that had shared agreement, is an indication of how willing or interested the other side of the aisle is on addressing the challenges facing Minnesotans today. So, members, I think that the green vote, the choice is obvious. We need to be declaring an emergency or an urgency to take this bill up and pass it today so that we can be making sure that Minnesota ratepayers are not footing the bill for excessive executive pay. Thank you, Madam Speaker.
I recognize the member from Hennepin, Representative Kraft.
Thank you, Madam Speaker. Thank you, Representative Greenman, for raising this. We need to do this. You know, XL, Centerpoint, these are monopolies, as was pointed out. And their returns are very safe, and yet they are making right now net profit margin 13.76% and a return on equity of 9.36%. They are doing very well as a monopoly provider. And what we're simply asking here is that the top paid executives, that doesn't get charged over the cost to our chief executive to ratepayers. They're doing very well for their shareholders, so their shareholders can pick up more of this burden. Now, Minnesota households are not doing as well. They owed more than $145 million in past due electric and gas bills as of February, 70% higher than prior to the pandemic. Now, there are other states that are doing things here that we maybe should consider. Other expenses like political influence spending, lobbying, donations, corporate jets, travel, lodging. So this is a good start, but maybe there's other things we should consider. Now, we talk about the amount of money here. We are talking tens of millions of dollars. And just to put a frame on that, there's a bill that I've carried on LIHEAP, Low Income Heating and Energy Assistance Program, where if we could have $40 million, we could extend that to 44,500 more households and extend it into the summer. So we're talking about amounts here that are legitimate, that are reasonable, that we should be looking at. So Representative Greenman, again, thank you. We should do this. These companies are doing exceedingly well, and their shareholders can afford to pay their CEOs.
I recognize a member from Rice, Representative Purcell.
Thank you, Madam Speaker, and I would request a call of the House.
Call of the House has been requested. Seeing 10 hands, there will be a call of the House.
Thank you, Madam
Clerk
Speaker.
will take the roll. Further discussion? Or I'm sorry, the clerk will close the roll. And Representative Purcell, you still have the floor?
Thank you, Madam Speaker. I yield the floor.
Okay, thank you. Next on the list is from Olmsted, Representative Smith.
Thank you, Madam Speaker. We've been talking a lot in this session about people who take advantage of our system to get rich on the taxpayer's dollar. No one is better at this scheme than big corporations and their backroom executives raking in huge fortunes off the backs of taxpayers. And conservatives, for years, including last year, have defunded public programs for fear of people gaming the system. I'll tell you what, members, there's no welfare queen like big business in the United States. They will take from our system, fleece the taxpayer, and give nothing back. Our tax dollars should not go to the very corporations that are price gouging our people. Minnesotans use their hard-earned money to pay for electricity and gas and their utilities so their families can stay warm at night and keep the lights on. And these publicly traded companies take that money and shower fortunes on their executives. Let's talk about one of those companies, shall we? Xcel Energy. In 2025, Xcel Energy had a U.S. income of $1.75 billion. Off of that huge amount of money, how much do you think Xcel paid back in federal income taxes? It's less than every single person in this room because it is $0. That same year, their CEO made just a hair under $16 million, which is 123 times more than the median employee at Xcel makes. And according to the company's own documents, $2.5 million of that CEO pay came from Minnesota jurisdiction of that company. $2.5 million. That's money that Minnesotans around the state are agonizing over at kitchen tables when they look at their budgets. And Xcel is taking that and paying it to their CEOs, making those massive bank accounts and stock portfolios just a little bit bigger. That is wrong. And by the way, in the midst of this, Xcel has the audacity to ask for a 13.2% rate increase for Minnesotans over the next 2 years. Look all this up. These are all true facts. So the question before the body is, do you care about these rate hikes for Minnesotans, or do you care about CEOs making more money? The people you represent, that I represent, the communities we come from, are struggling, and they're powered by a massive energy corporation, many of them by Xcel, where these price hikes are paying this CEO's salary. From 2021 to 2025, Cottage Grove residents' rates were raised by 28.4%. Wayzata residents, 28.4%. Lakeville, 22.8% increases on those rates. In that same period, that CEO pay has increased 97%. There's no more giggles over there. Why would you vote no on this bill and protect CEOs who are getting absurdly rich off of Minnesotans staying warm in the winter? You can distract all you want by talking about Governor Walz or other accounts that we have in our state budget. But before you is the question, should taxpayer utility bills subsidize CEO pay? And I still have not heard a reason why you would side with CEOs over Minnesotans. I just heard a ton of deflections. And the reason that you cannot give me a reason is because the reason is horrible. And it's because corporate lobbyists are telling you to vote no on bills like this. That's why you won't say it out loud. And if I'm wrong, prove me wrong. Let's vote yes on this. Let's vote with Minnesotans over CEOs. I have a feeling that's not going to be the case.
I recognize the member from Anoka, Representative Niska.
Thank you, Mr. Speaker and members. Well, you might be, confused, normally when we're under call, it's because we're having a serious debate about a serious issue. Members, this is not a serious proposal. We know it's not a serious proposal because we heard that it's like a couple of pennies on every ratepayer that we're even talking about. Sure, it sounds like big numbers. In the scheme of Xcel Energy's rates, their revenue, fractions of a cent. This is, as we heard a DFL leader just this week say, don't threaten me with a good time. This is just plain old class warfare. It's not a real serious proposal. It's about trying to find the bad people and telling Minnesotans that they should go eat them, or talking about those were the words of a French revolutionary that were quoted by a DFL House member. So if we want to be against political violence, let's not engage in that. But for those of you who have actually been involved in a business that didn't fail, you know that hiring is a very important aspect of that. And when you hire somebody, you get what you pay for, and you need to pay people what they're worth in order to get good, competent leadership. So if you want Tim Walz level incompetence running Xcel, or Tim Walz level incompetence running Centerpoint, vote yes. It's a great idea. I don't think Minnesotans can afford that because we can't afford Tim Walz level incompetence anywhere else. We sure don't want Tim Walz level incompetence at the utilities that we rely on to heat our homes, to cool them in the summer, to actually make sure that our electronics charge when we plug them into the wall, because electricity doesn't come out of the wall. We actually need people who understand how to run those businesses to run those businesses. Minnesotans can't afford Tim Walz level incompetence anywhere, including at our electric utilities. Vote no.
I recognize the member from Hennepin, Representative Long.
Thank you, Madam Speaker. Well, good news for you. We've heard that this is going to be a bill that's going to chase our executives out of the state. Well, we have a pretty good example, which is that Colorado passed a very similar bill, and Xcel Energy also operates in Colorado. And guess what? The CEO is still the same, and the CEO is paid the same rate. But guess who's not paying that salary? It's the ratepayers in Colorado. We have seen Minnesotans be saddled with high prices for gasoline, high prices for energy, for groceries, for health care, for food. And this is one step that we can take to actually reduce their electricity bills. We heard from Representative Swedzinski that this was too small potatoes, too small change. If we were able to do $50 million, Representative Swedzinski said, then it would be worth it, because that's what was available in the RDA. Well, I did a little bit of back of the envelope math, and if you just take the top 5 paid CEOs, executives for Xcel and Centerpoint, and this bill covers the top 10, then you get to $57 million. $57 million that we would be saving ratepayers. So that's $7 more million than you were asking for, Representative Swedzinski. And if we wanted to do something with the renewable development account, great. Why don't we give it back in energy assistance to ratepayers? That's something that we propose over here as well. But if you wanted to save $57 million plus, and that's real money for ratepayers, that will not affect anybody's job. The same people will still be employed and likely at the same salary. It will just be paid for by their shareholders and not by the ratepayers. This is a serious proposal. It will save money, and you all should be voting for it to try to help make sure that Minnesotans who are struggling with costs of energy and other things can save money. Thank you.
I recognize a member from Hennepin, Representative Greenman.
Thank you, Madam Speaker. This is a serious bill that other states have done that is easy. All it says is we are capping the amount of CEO pay from our investor-owned monopolies that ratepayers have to pay. It is a serious proposal, but it is clear that the Republican leader is not taking it seriously. Neither is the Republican chair. I didn't hear a single reason in favor of making ratepayers pay for millionaires who are and billionaire companies. I did hear, and was actually surprised to hear the Republican chair say that Minnesotans, that we should be tithing to millionaire CEOs, while Minnesotans are on the hook to pay for it. And that is certainly something we heard Excel and Centerpoint say they wanted us to do. In committee, we heard from many ratepayers from different parts of the state telling us both about their bills, but also that they just didn't think it was fair. And you know what? When Excel, they sent a lobbyist, and Centerpoint sent a lobbyist, and what they said was the system works fine as it is, because it does work fine as it is for them. Because millions of dollars of their executive compensation is being charged to ratepayers, and there's nothing ratepayers can do about it because they are a monopoly. And so yes, they don't want us to change this, but we're not here to represent Excel, we're not here to represent Centerpoint, we are not here to tithe to billionaires and millionaires. We are here to protect taxpayers and ensure that with these investor-owned monopolies, that people are getting a good deal. And so here we are, like many of you, we're not on Energy Committee. And so you're getting to look at this for the first time. And it is a one-page bill. And again, it's not that complicated. All it says is that the PUC can only reimburse rates up to the governor, which is $177,000. So we should be with everybody else. We should be with the Minnesotans. We should be with our people in our community who are saying, don't let these CEOs rip us off. Don't let these investor-owned utilities who are making a guaranteed profit from us also charge us back for our compensation. And if you need any reason, if you're on that committee, to change your mind, the fact that that Excel boosted their CEO salary by 45% this year shows that they can afford it. And if we don't do this, what we're telling them is that you can continue to raise your CEO's salary and Minnesotans will be on the hook. So this is an easy green vote. And I hope that everybody, 90 votes at least, that we do this, because it's an easy green vote. And we can go on to all of these other bills we talked about, all of these other conversations. But again, all we are saying here is that we are not going to pay more for the CEOs of Excel and Centerpoint than we do for our own CEO, who makes $177,000. Members, vote green.
The clerk will take the roll. The House is under call. Members, please vote. The clerk will call the names of the members participating remotely.
Green.
Green votes green.
Green votes aye. McDonald.
McDonald, no.
McDonald votes no. Momani Hiltsley.
Momani Hiltsley, aye.
Momani Hiltsley votes aye. Perez Vega.
Perez Vega, aye.
Perez Vega votes aye.
The clerk will close the roll. There being 69 ayes and 61 nays, the motion does not prevail. Announcements. I recognize the member from Anoka, Representative Niska.
Thank you, Madam Speaker. I move that when the House adjourns today, it adjourns until 1 p.m. Monday, May 4th, 2026.
Representative Niska moves that when the House adjourns today, it adjourns until 1 p.m. Monday, May 4th, 2026. All those in favor say aye. Those opposed, nay. Motion prevails. Representative Niska.
I move that the House do now adjourn.
Representative Niska moves that the House do now adjourn. All those in favor say aye. Those opposed, nay. Motion prevails and the House stands adjourned until 1 p.m. Monday, May 4th, 2026.